Leave to mention an application to be filed, my lord, without certified copy, my lord.
Leave granted.
My lord, may I have your lordship's leave to mention an extremely urgent matter, my lord, item number 404 of the monthly list, my lord. This pertains to, my lord, fake doctors practicing in the state, my lord. There was a my lord, previous orders of this court, pursuant to which, my lord, the Director of Health Services conducted an inquiry. 2 reports filed, my lord, as on date, at least 634, my lord, were found to be fake, my lord. These are Unani practitioners, my lord. Now, my lord, the report also indicates, my lord, that the registrar of the Unani Council, my lord, he is the prime suspect, my lord, and he is the perpetrator in issuing fake certificates to these persons, my lord. Now, my lord, that registrar, my lord, who was previously removed, my lord, if I may take, my lord, that registrar of the council, my lord, he has been appointed, once again appointed as the registrar, my lord, as of the council, my lord, pursuant to order, my lord, we have filed an application.
You will upgrade it. You upgrade it.
My lord, may just to add one more. Findings returned by the government, by the Director of Health Services, says that he is instrumental in giving this certificate.
But still he is rewarded.
And my lord, very strange.
You give notice to
Yes,
the
Unani Council. No, you were there in the matter. He is there. He is, when he roams in the corridor, we call him Rajya Sarkar. So he is there.
No, you give notice to whoever is going to appear in
yes,
the matter.
Mr. Advocate General is going to appear. I'll inform him.
You inform. You will upgrade it. Yes.
My lord's permission, I kindly mention for an upgradation of a matter, my lord. It's there in the monthly list, my lord. 773, 770.
I'll be praying for leave to file the appeal without the certified copy.
Leave granted. Yes, please call the list.
Appellate side.
My lord, one mentioning, my lord. The matter I have been mentioning for several occasions, my lord. The goods are still lying. Seized, my lord. Goods have the expiry date.
Yes.
The betel
Please call.
Appellate side, daily list, serial number 1.
Yes, sir.
Yes. My lord, my issue is in very narrow compass. My lord, the London single judge passes an order on 23rd of June 2023. So far, my prayer in the writ petition was twofold. One was challenging the vary of the provisions. That is a one part. The second part was the challenging the so-cause notice. London single judge simply observed that I am not inclined to interfere in the so-cause notice without adverting to any facts and my legal submission at all. Whereas the so-cause notice is not only without jurisdiction, it is known as in the law. If the barely on the so-cause notice, it is not signed, it is no facts, nothing is given.
Let us see the so-cause notice.
Yes, my lord. Kindly see the so-cause notice, my lord. It is on page 221. It barely extracted the provision of the law.
221.
P18. Yes, my lord. The so-cause notice under section 73. It has come to my notice that the tax has not been paid, or short paid, or refund has been released erroneously, or input tax credit has been wrongly availed or utilized by you, or the amount paid by you through the above referred application for intimation of voluntary payment for the reason and other details mentioned in annexure for the aforesaid tax period. This is the section, what the section 73.
Normally, there will be a annexure to this notice.
Yeah, there is no annexure, my lord. One report of earlier date. This is the
page 226, my lord.
Yeah, my lord. Let me put my case. This is the so-cause notice, my lord, dated on 10th of May. There is another report which I have also challenged. That is the prior to the so-cause notice date. That is the 8th of May. Kindly see the page 229, my lord. 229. At the bottom, my lord. It is the 8th May 2023.
Please also note that as per so and so, if you pay the said tax along with so and so, deemed to be
and but both are not signed.
Being issued under section 73(1). That is
no, this is actually an intimation. Page 229 is an intimation to the assessee that as per 73(8), if you pay, it is deemed to be closed.
No, this is the annexure to the show cause notice.
It can't be.
Because intimation was given prior to that.
My lord, it is the 8th May and the so cause notice is the 10th May. My lord, kindly see page 221. Page 221.
It was uploaded in the server on 10th May.
Then you could have said in the notice that we are relying upon the report.
It is not stated at all.
That was already annexed. Your Lordship, kindly see page 212. 212. That is the intimation notice which was issued on 20th April 2023. And its report, my lord, the annexure to that notice is at page 214. 214.
This is a report, yes.
This is the intimation notice, that is. And thereafter, my lord, this show cause notice was issued. And the Honorable Single Judge granted him liberty to approach the authorities, filing reply to the show cause notice, taking all these
You
points.
please come to 217.
217. 4th May 2023.
He says that please be informed that we do not agree with the allegations and your demand for tax. We shall submit a defense in case the department will proceed to issue any show cause notice as required under law.
Right.
Normally, a show cause notice is differently worded. We have seen several matters.
But in this case, because this was a case of with regard to, my lord, this is a typical case. This is a case, he is a promoter. But the promoter says that I am covered under this old liability. So the promoter says that I will reverse the input tax credit from December 2020 till date. But the law says, according to the circular, that is why he has challenged the virus of Rule 43(2). The law says, my lord, that since the date when you have covered, from that date, my lord, you have to discharge your liability. From that date, you have to do it, because this is altogether different wing, which is with regard to discharging of liability. So the wording is that it is in the form of a report, but it was always attached to the show cause notice. And the Honorable Single Judge has rightly, my lord, because your Lordship knows, my lord, there are plethora of judgments that the courts will not interfere in this at the stage of show cause.
Sir, one thing, please come to page 228.
228, my lord. Yes, my lord.
In the middle, you are therefore required to show cause as to why you should not pay the amount specified in the table below along with interest. You please treat this as a material and give your reply.
Yes, my lord, may I just submit that 2-3 things why I have challenged the so cause notice. It is not a simplicity so cause notice I have challenged. First thing is that the so cause notice is known as in the law. First, it is not even a signed document without
No, it is this one, no? Computer generated.
No, my lord. The Bombay High Court and Delhi High Court have gone into that issue. Merely because the computer uploaded is not a signed document. It has to be signed and it has to be digitally signed.
No,
Come to the page 2 to 3.
229 is digitally signed.
No, my lord. 2 to 3, my lord, is the so cause notice. That is not a so cause. That is maybe an annexure. Kindly come 2 to 1.
This is a statutory form, sir. 212.
Mitra Pal designation name is given. Signature has been, my lord, these are all digitally signed.
2 to 1 to 2 to 3. 2 to 1 to 2 to 3. That is the so cause notice.
Yes.
Yes. And if the signature, my lord, see that there is no signature. First, that is the first point, my lord.
No, 2 to 3, there is a signature.
No, there is no signature, my lord. It is the name mentioned. Signature is not there.
It has to be digitally signed. So it says signature column blank. This is all hyper technical.
No, my lord. I'm not on that issue at all, alone. Second point, my lord. Second point.
If you challenge the vires of the act, unless it is struck down, it's deemed to be valid.
Yes, my lord. Kindly come to the second point on page 221. Because the learner single judge is not going to advert any facts or any of my contention at all. Simply said, I am not inclined to interfere in the so cause notice. Now the 2 to 1, my lord, kindly see the so cause notice under section 73. Every possible things extracted from the section alone. It says, it come to my notice that tax has not been paid. It is nothing there in the so cause notice. I have not paid any tax. Correct. Second point, it says should not be paid, should not be refund has been released. There is nothing refund like this. Next, it says erroneously refunded. No such allegations
then or input tax credit has been wrongly availed. In the first judgment, my lord, same word before Delhi High Court, the same so-called notice and similar. And even in the earlier judgment of this Honorable High Court, also in, my lord, kindly see the first judgment marked the page 1 on the para 8, my lord, para 8. Same to same so-called notice. If I read with this judgment and my so-called notice word to word same. Allegation made in the so-called notice set out below. It has come to my notice that the tax due has not been paid or short paid or refund has been released erroneously or input tax credit has been wrongly availed or utilized by you or the amount paid by you through the above referred application for intimation or voluntary payment for the reason and other detail mentioned in annexure for the aforesaid tax periods. Exactly word to word. Now, my lord, para 9. It appears that the so-called notice does not spell out allegation which is required to be addressed by the petitioner. The purpose of the so-called notice is to enable the noticee to respond to the allegation. In the present case, it is seen that it is a journal notice stating that the tax has not been paid or short paid or refund has been released erroneously or input tax credit has been wrongly availed or utilized. This obviously provides no clue as to the reason for purpose of any action. And if, my lord, I read with this annexure, my lord, kindly come to the annexure which has there been attached. It is nothing like this. There is no synchronization between these two. And the 221 is the respondent number, my lord, is the 221 is issued by the respondent number 3. Whereas the annexure is from the office of the respondent number 4. And
So therefore, your case is that there is no allegation, it is not specific, it is not signed.
yes, it is a vague so-called notice, totally vague. Now, my lord, come to this, my lord, the earlier this Honorable High Court has gone into that issue in the serial number 4, my lord, of the judgment of this Honorable High Court, page 14. If any so-called notice which itself is a vague, because the Supreme Court in serial number 3 said the so-called notice is the foundation of the case. It cannot be so vague. If my lord kindly come to the page number 14, this Honorable Court, coordinating bench, kindly come to the
Para 16.
para 16, my lord, para 16. In our opinion,
No,
whether they have the power to do
No,
so.
there is no requirement of any decision on that.
Yes.
Show cause notice should speak for itself.
Yes, my lord. It cannot be so vague putting me how to answer to that. It has to be very specific allegation what I have to answer to that. It cannot be copy paste of the provision of the law, what has been stated in section 73, all possible things.
So far as the validity of the provision, court has entertained.
Yes. And one more thing is that in the similar facts, my lord, similar fact is situated. Final judgment came in serial number 8 in the previous law of the service tax. Gujarat High Court said, what I am, my lord, I am the promoter, I am the builder. I am availing credit. And as per this law, GST law, if I will not pass on that credit to the buyer, then the anti-profiteering provisions are there under section 171. I have done it. Now my project has been completed on a particular day. Thereafter, I am not entitled to take a credit. I am not taking a credit. What they are asking me, the credit which you have already taken, utilized, reflected in the return, you reverse that credit. How I can be?
That's on the merits of the matter.
Yes, I am not. I am just putting, my lord, the para is serial number 8. The similar fact, the final judgment also came of the Gujarat High Court, page 42, 46, if precisely page 45, para 17. The similar facts, my lord. Therefore, the London single judge, without adverting to the what I am challenging. Now, the one more point, my lord, there is a monetary limit has also been fixed. I have annexed that. If there is a pecuniary limit he has exceeded without jurisdiction, at least London single judge was bound to see my this. My lord, I have annexed the annexure. My lord, kindly see. Kindly see here, P19 230. 230. There is a pecuniary jurisdiction. GST Council has decided on the basis of that. Pecuniary jurisdiction, page 230, P19, my lord. Now the state and central are uniform. They have to circular notification are uniform. This is the circular issued in 2018, my lord. Kindly come to 232. Pecuniary limit has been set for the superintendent, deputy commissioner, additional commissioner. Deputy commissioner limit is not exceeding 1 crores. Table, my lord, kindly see column number 3. If the CGST and then IGST, here is, more than 3 crores, then only the additional commissioner or the joint commissioner issue. My only humble submission is that if I'm challenging the jurisdiction, authority, and the vagueness of the so-called notice, at least London single judge should have adverted to that. My lord, kindly see one line only. One line in the impugned order, my lord, kindly see page 43, rather page 44, page 43 at the bottom. And page 44 precisely said, file the writ petition for interference of the aforesaid impugned so-called notice, which I am not inclined to interfere. Without adverting to what exactly
We will advert to it. Please come. This intra-court appeal by the writ petitioner is directed against order dated 23/6/2023 in WPA 13600 of 2023. In the said writ petition, the appellant prayed for issuance of a writ of declaration to declare Rule 42 (3) of the CGST Rules 2017 as ultra vires the Constitution of India. The appellant had also challenged a show cause notice dated 10th May 2023 issued by the third respondent under section 73 of the WBGST Act. The learned single bench had entertained the writ petition so far as the challenge to the constitutional validity of Rule 42 (3) of the said rules. However, with regard to the challenge to the show cause notice, the learned writ court was not inclined to interfere or interdict the show cause notice and directed the appellant to file an appeal. Agreed by such order, the appellant has preferred the present appeal. We have heard so and so. The sheet anchor of the argument of the learned advocate appearing for the petitioner appellant is that the show cause notice is devoid of any reasons. It is not specific, it is vague, it is not signed, and does not contain the requisite details, and it can never be regarded as a valid show cause notice in the eye of law. In support of his contention, the learned counsel placed reliance on the decision of the Honorable Division Bench of the High Court of Delhi in this serial number 1, Marg EPR Limited versus Commission of Delhi Goods and Service Tax 2023 SEC Online Delhi 714. For the same proposition, reliance was placed on the decision of the High Court of Allahabad in Apparent Marketing Private Limited versus State of UP 2022 59 GSTL 399 Allahabad, and the decision of this court, of the division bench of this court in Delta International Limited versus Commission of Customs 2012 281 ELT 400 Calcutta. Further, it is submitted that that the input tax availed by the appellant till completion certificate was issued for the building promoted by the appellant is not required to be reversed, and this aspect of the matter also will render the impugned show cause notice as bad in law. In support of such contention, reliance was placed on the decision of the High Court of Gujarat in the Principal Commissioner versus Alembic Limited 2019 29 GSTL 625 Gujarat. Further, it is submitted that the impugned show cause notice is also bad in law on account of lack of pecuniary jurisdiction on the part of the authority, namely the third respondent who issued the show cause notice. In this regard, reference has been made to the circular issued by the Central Board of Excise and Customs in circular number 31/05/2018-GST dated 9th February 2018. We have heard the learned Mr. T.M. Siddiqui, learned government counsel, on the above submissions. The show cause notice dated 10th May 2023 has been issued under section 73 of the WBGST Act. In the said show cause notice, the demand details have been mentioned, and the name of the Deputy Commissioner who issued the show cause notice has also been furnished. The show cause notice is in a statutory format, which has been uploaded which has been forwarded to the registered email ID of the appellant SSC along with the statutory form, namely form GST DRC-01, which is the summary of the show cause notice. Interestingly, along with the show cause notice, a report in the matter of the SSC, appellant SSC, dated 8/5/2023 has been appended. It is a submission of the learned advocate for the appellant that the show cause notice is dated 10/5/2023, but the report is dated 8/5/2023. And therefore, the report cannot be treated as a show cause notice. However, it is seen that much prior to the to issuance of the show cause notice dated 10/5/2023, the report dated 8/5/2023 was forwarded to the SSC along with form GST DRC-01A capital A dated 10/24/2023. In the said notice, the appellant was advised to pay the tax as ascertained along with the amount of applicable interest in full by 5/5/2023, failing which show cause notice will be issued. Further, the appellant was granted liberty to file their submissions against the ascertainment which was done in the report dated 8/5/2023. In the report, ascertainment which has been done in the notice by 5/5/2023. Thereafter, another notice was issued on 4/5/2023. Prior to the issuance of said notice, the assessee had on the same date, namely 4/5/2023, the assessee had submitted a representation to the Deputy Commissioner of Revenue, Office of the Charge Officer, Park Street Charge, Kolkata. In the said representation, it was stated that in the said representation, they have acknowledged the intimation received under section 73 within bracket 5 of the CGST Act 2017. The assessee stated that they do not agree with the allegations and the demand of tax along with interest for the alleged inadmissible ITC. Therefore, full stop. They further stated that they shall submit their defense in case, the department will proceed to issue any show cause notice as required under law. Thus, in terms of the request made by the assessee, show cause notice dated 10/5/2023 has been issued along with the statutory form, namely form GST DRC-01 dated 10/5/2023, in which the report has been appended. On a perusal of the report, it is seen that it has been explicitly stated that the appellant is required to show cause as to why they should not pay the amount specified in the table in the said report, along with interest payable and penalty leviable thereon. Therefore, the assessee should treat the annexure to the notice, namely the report dated 8/5/2023, as the material based on which they are called upon to show cause as to why the tax which has been computed should not be recovered along with interest and penalty. Thus, we are fully convinced that the show cause notice is neither vague nor lacking in particulars, and it is for the appellant assessee to raise all contentions in this reply, which will include the contention regarding the pecuniary jurisdiction of the authority which has issued the show cause notice. In the decision in the Marg ERP Limited, the factual position was slightly different, as could be noted from paragraph 8 of the decision, 8 of the judgment. And therefore, the court came to the conclusion that the show cause notice does not spell out the allegations which is required to be addressed by the petitioner therein. The case on hand is entirely different, as we have set out in the preceding paragraph. Equally is the decision in the case of Apparent Marketing Private Limited and Delta International Limited. In any event, the issue as to whether a show cause notice is vague and lacks detail or is unintelligible to qualify to be a show cause notice cannot be put in a straitjacket formula and cannot and has to be decided considering the facts and circumstances of the cases on hand. Therefore, we are fully convinced that the learned single bench rightly refused to interdict the show cause notice. Accordingly, the appeal fails and is dismissed, and the appellant is granted 15 days time from the date of receipt of the server copy of this judgment and order to submit the reply to the show cause notice, in which all points of contentions with regard to the facts as well as law can be raised by the appellant, and the authority concerned shall decide all issues which have been raised by the appellant in accordance with the law and passes recent and a speaking order. Next.
Serial number 2.
Millard, this is my application for review, Millard,
Yes.
where I was not a party, Millard. Allegation in the public interest litigation that my clients have constructed, Millard, a house without any permission, and that too on a water body. Now, Millard, in pursuance of your lordship's direction, Millard, the concerned officer, Millard, he has issued a notice for demolition. Now, I have 2 points.
Now, where is the notice of demolition?
Notice of
Page number?
Yes, Millard. তাড়াতাড়ি বার করো না। Page 20.
No, if you have got a patta or some land document.
I purchased a land. I have two
Or
specific.
vendor. You please understand, please let us, if you have got a valid document, either, of course, a deed of conveyance is one document, but you should prove that your vendor had title to sell the property to you, had a proper title. And where is the show cause notice? I mean,
Millard, this
demolition.
notice, Millard, page 21.
You raise your objection, we will consider. No,
We will consider.
page 21.
They have decided, Millard, the notice of the show cause, Millard, is a capsule
You
mind.
produce, sir, you show a valid document.
Yes,
Saying that you are in lawful possession, it is not a water body, it is not a vested land, you are not an encroacher. Probably there may be 10 sale deeds. If ultimately the first person who sold the property did not have title, everything is void ab initio.
But if I kindly takes you from your lordship's own order, Millard. Lordship has passed this order on the basis of the documents that I have shown, Millard.
All right, now suppose he has got something in his pocket, let him show it.
There was a
Only-
notice
Yes, but
after
only
hearing the
document,
order was
Millard,
passed.
no,
the
I
document
request.
which Mr. Bose has filed, Millard, with this, Millard, it's classified as pond. Page 19, Millard, kindly takes once, page 19 of his petition, Millard. It's classified as pond.
No,
Doc number
I
187.
have 3 submissions to make, which is on merit. Now, Millard, if your lordship sending it back to the authority, I am going
Now,
to.
what do you say for ground clearance?
No, Millard, I tell you.
It is, Millard, apparent that its land is
Millard,
classified as
No,
Recorded as pond
but the real picture, Millard, Mr.
and
Basumollik's
hearing was
client,
given, Millard.
Mr. Basumollik's client has not submitted 2 things. What was the satellite position, Millard, on the date when I purchased the land? And I said specific averment. Number 2.
Chandrayaan-3 just now landed in the moon.
No, Millard, satellite, Millard, in matter, Millard, NGT, Millard has passed order. Section 70A in I of,
Sir, you have to get over. Sir.
no, my lord, kindly ask them to give me hearing. I will produce documents that I'm a bona fide
No,
purchaser.
According to the ground pleader,
Millard, according to the government pleader, Millard, this is a land, Millard, recorded as a pond. This record, Millard, but I have, Millard, the submission that when I had purchased, Millard, there was no existence of pond on my land.
that is correct. See, there are 2 things to it. One is a land may be classified in a particular category. But the characteristics of the physical features of the land may not resemble the
Right.
characteristics.
Right?
So that does not mean that it ceased to be a pond.
No.
That can be a reason
Yes.
for probably applying for a reclassification, saying that for conversion of that into Bastu land or.
I'm extremely grateful. I'm extremely grateful. I'm extremely.
PLLRO, there is lot of
Yes,
procedure.
yes, absolutely. Section
Lordship is
40 of the.
more aware,
Millard, my lord Justice Bhattacharya is well conversed with this, Millard.
Yes.
So
there
He has
is all
started
the
his
more you
career
don't
with
have a
this,
case.
Millard. Now, Millard, that Millard, kindly give me an opportunity to place my case
This only
No,
track.
my lord, only I tell your lordship, my lord, I have two
You take,
submissions.
if you want 15 days time, 20 days.
No, my
time,
lord, kindly, my lord,
make a
my
request,
lord,
you will-
kindly, my lord, only, my lord, only I have two submissions to make. My lord, first of all, I said, my lord, when I purchased the land, my lord, it was not possible for me because the land has already been classified as,
No, no,
my
no.
lord, kindly says.
Maybe a tempter.
My lord, only,
You have to see the.
my lord, I
land.
have not committed any wrong, my lord. Number one. Number two, my lord, I will show it to your lordship.
Probably
one
you are
provision.
cheated. You are
My lord,
cheated.
I will show your lordship one provision, my lord. My lord, my erstwhile vendor, my lord, who has committed, my lord, the alleged mischief, my lord. Only, my lord, I show your lordship, my lord, the one provision.
You file a case
One-
against your vendor.
No, my lord,
You claim compensation.
yes,
You lodge an FIR against him. Everything. We will direct FIR to be registered.
no, kindly, my lord.
Jurisdiction.
Only, my lord, the
Normally you are
provision of
asking police
provision of
action.
provision of section 17A on the basis whereof, my lord, this allegation, my lord, this conversion is permissible on a condition that I have to excavate a pond. The extent of land, my lord, that is a provision.
That is cheating the society, sir. That is cheating the society.
My lord, that is the legislative wisdom.
Nothing doing. He is the trustee. He has got no business
my
to
lord-
reclassify. He has got no business to reclassify. He is a trustee of all these lands which have been classified as waterways, ponds, small water bodies, etc. He is a trustee. He shall hold it on trust
Yes,
on behalf of the entire citizenry.
yes,
of
that is the
state.
doctrine of public trust, my lord.
Yes.
Yes,
It is
it's a,
clear
yes,
proof.
I know, I'm aware of this, but despite
The
this,
Malik client
yes,
does reclassification. It's a clear
yes,
breach of
no,
trust.
but then, my lord, kindly ask Mr. Boshumallik that in West Bengal, within 5 years or 10 years, how many lands have been classified from
Illegal,
pond?
illegal.
No, but,
bring it up,
but
you
they
bring
have,
it up.
no, number
You
one,
set aside
number two,
everything.
my lord, whether the section 17A.
You take, there is a decision of the full bench of the Madras High Court. As part of the full bench, you read the decision.
My lord, kindly
And what the
permit me,
government
kindly
did
permit,
and what the court did.
my lord, permit me, my lord, the section 17A, the legislature
This
was,
is fraud on power, sir. This is
This-
fraud on power.
but this provision is still alive.
Let it be alive. It is an illegal provision. Needs to be struck down.
My lord, kindly, my lord, I can take recourse to this, my lord. I am saying, my lord,
You have not
ecological.
done so. As on date, you have not done so. Let it be
My
restored.
lord,
Then you file an
my lord,
application.
my mentor, my lord, I am a person, my lord, that who are financially, my lord, absolutely challenge people. My lord, we have purchased the land, my lord, investing the, my lord, kindly, my lord, allow me to excavate, my lord, that amount of land because I have not committed
This
it.
review application has been filed to review the order and judgment and order in WPA 243 of 2022 dated 24/4/2023. It is submitted that the appellant's, the review applicant was not a party to the writ petition, and behind his back a direction has been issued pursuant to which the subdivisional officer Basirat, North 24 Parganas, has issued notice of eviction dated 26/5/2023. Therefore, the applicant has filed the present review to review the judgment and order dated 24/4/2023. As rightly pointed out by the learned government council, the land in question has been classified as a pond in the revenue records. As long as the said classification has not been altered, no person has got any vested right to claim that they are entitled to construct a building in a land classified as a pond. The learned advocate appearing for the appellant would vehemently contend that the appellant had purchased the land and the appellant is economically in a poor condition, and there are provisions under the various laws enacted by the state of West Bengal which provides for conversion of a land which is classified
Alternate water body I can create.
as a water body into a Bastu land or a homestead land. In any event, such a request was neither made by the applicant nor his vendor or any predecessors. In any event, such a power, even though if it exists under the statute, the state, while exercising that power, should bear in mind that the state is the trustee of such water bodies and waterways and ponds, and any arbitrary exercise of the power for conversion of the land would be against public interest and would amount to breach of the public trust reposed on the state, which is bound to protect such assets for not only the present but also for the posterity. Thus, we are thus the applicant has not made out any ground to review the judgment and order dated 24/4 so and so in WP number so and so. Accordingly, the review application is dismissed. The applicant is
But
granted.
if I make an application for conversion, my lord, to them,
Applicant is granted 10 days time from the date of receipt of the server copy of this order to comply with the demand made in the notice dated 26/5/2023 is issued by the subdivisional officer Basirhat, North Pargan,
will
24
your lordship give me, my lord, 30 days time so that I can test your lordship's order in the Supreme Court?
Today we will upload it. Tomorrow you can file it.
Right,
E-filing.
My lord, I have,
Already, my
Monday
lord,
you
I
can
was-
mention.
give
I
me, my
was-
lord, 15 days time, my
I
lord,
was instructed,
my lord, so that I can
some people
challenge.
have went up to Supreme Court, the SLP is
No,
pending.
no, I am not, my lord, so that 50,
That
instead of
SLP
10,
has pending, my lord.
my lord, instead of 10, my lord, give me 2 weeks time.
15 days. 15 days time.
That's
Next.
grateful, my lord.
Thank you.
Serial number 3.
Yes.
This matter was heard on 28th of February 2023, my lord. And a interim order was passed, my lord, which is a supplementary. I filed a supplementary, page number 6 of the supplementary affidavit.
This amount has been paid.
My lord, 6,07,000 has been paid, my lord.
Very
My
good.
lord, before the filing of this application, my lord, they have already taken out 3 crores, near about 92 lakhs, my lord. That is why I could not pay the residuary for the reopening of the bank account, my lord. 25 lakhs was, my lord, paragraph number.
So this 25, according to you, more 3 crores has already been swiped.
My lord, in paragraph number of the affidavit, my lord, my lord, 5,
Para 5. Of
the last line, my lord, the page number 4, my lord. Total amount debited being rupees 3,98,09,291. Therefore, your petitioner is not in the position to pay 25 lakhs. my lord. But
What is
and
your
all the
instruction?
documents has been adduced to this, my lord.
What is your instruction?
I yet to take instruction, but lordship kindly see what is the last date of debit? Para 4.
On 3rd March.
No, lordship is 17th March. Last debit. First paragraph, last 3 lines. So that is the last date of the debit, according to him.
March 17, 20.
It's the last date of the. Kindly see the last order when the trial court passed down. Kindly see the impugned order of the trial. Date, only date. The impugned order passed
On 24th March.
lordship. Then lordship's order passed is on page 6.
28th April.
So all this hearing, he was aware of this amount deducted. Order passed by your lordship thereafter. So lordship, basically what he is saying, to modify or recall of one part of the order.
But then if suppose already
No.
more substantial
No,
amount
this is
has
not,
been.
this is one
Well,
part.
may I
Now the
submit,
second part of it. I have deducted, I have recovered whether regarding to this or not. Even I do not know even today. First, though, I have been settled with a
Then you
response.
do one thing, you get your written instruction,
My lord,
whether this 3 crores and odd was towards the other show cause notice. I mean, towards this very demand. Otherwise, it will be very.
my lord, in the month of May,
No,
they
lordship,
came
I
back.
am saying, I
My
would
lord,
have
my lord,
understood it.
Please.
Oh, sure.
Or in the month of May, the hearing was kept, my lord. Before this affidavit was filed, my lord, I handed it over to them, my lord. This is August, my lord. And there was a specific direction, my lord. They are not seeing into your lordship's order passed, my lord. There was in paragraph number 6, my lord, it was specifically stated. That-
No, on the date when we passed the order, what the submission of the learned friend is that this amount which was swiped off your account
my lord.
was done prior to 28/4. That's it. On 28/4, the division bench
True,
passed
ma'am.
the order. Prior to that, on 17th March, it has been
My
done.
lord.
You could have brought it to the notice of this court.
My lord, in the month of May, my lord, it was, my lord, I did not know it, my lord, I did not have the instruction, my lord. This is the,
Code
my lord,
debited in March.
my lord, can the petitioner be remedialist, my lord, in this case, my lord?
No, it's not that way.
But then, my lord, in the month of May, I've served upon them.
I
My lord,
knew
they
this,
ought to have
Lordship,
taken
because of the
instruction in
para
just 2
5.
months, my lord.
Lordship, para 5 of your lordship's order,
See,
by paying, kindly see, para
this
6.
amount of which was debited from your account, rupees 3.98 crores,
Well,
was done in March 17, 2020.
Before filing the application.
Before the writ petition. So therefore, you should have
Before
told
the applicable appeal, my lord.
before the appeal. After the writ was order was passed,
Yes.
and when the appeal was filed.
My lord.
So you could have brought it to the notice of the court saying that no further condition be imposed. Already 3.98 crores has been recovered.
My lord, I say against this, my lord, there was an instruction to pay 6 crores, my lord, against the demand, my lord. And for the bank, reopening of the bank, 25 lakhs was to be paid, my lord.
Yes.
My lord, I did not seek to reopen my bank as because I did not pay 25 lakhs, my lord. Well, it is no case of them, my lord. My lord, in the month of, again I say, my lord, paragraph number 8, my lord, lordship comes, my lord.
Paragraph
In the
6
light
of
of
your
the said
lordship's
submission, we
order.
direct that the appellant to
Lordship, kindly
deposit
see.
further sum of 25 lakhs to the respondent
What's the
department,
logic?
which shall abide by the law by a further order passed in this writ petition, in compliance to the twin condition, namely the payment of rupees 6 lakh this and 25 lakhs the attachment of the petition bank account shall be lifted, my lord. It is as
No,
regards to
Lordship.
the attachment being lifted, my lord. But my lord, 6 lakh has been paid, my lord, in spite of the
Yes.
fact that I had paid them excess, my lord. 6 lakh as per your lordship's direction, my lord, I paid it, my lord. By borrowing wherever I go. My lord, I have whatever the bank account I had, my lord, they have attached everything, my lord. My lord, kindly see, my lord.
But
My
one
lord,
thing,
from 28th of March, my lord.
but one thing, 20, if suppose you have already debited 3.98 crores out of the total demand of rupees 6 crores, 50% has already been recovered. Then still keeping the bank account attached, he can't do any business.
My lord, since last December, I'm
So
not
this
doing any
25
business.
lakhs we will dispense with, and then we will hear the appeal.
So lordship, kindly see. The very point, short point in the appeal.
We are not asking you to refund. We are just
No, lordship.
dispense with
Kindly
the
see why
evidence.
this happened. Paragraph 6 gives him the complete protection. Kindly see.
My lord, if I do not have
Sir,
any
please allow
amount
me
in
to
my bank
finish.
account, my lord, what protection do I need, my
I
lord?
know. So lordship, kindly see.
So penalty he has been protected.
He has been protected.
Yes.
Now lordship, bank account. Now lordship, with regard to the bank account, lordship has passed this order because my revenue huge sum is due. And
Unless you allow him to do business, how will you recover?
lordship, I will not allow to someone do business who will go away with my money. I will allow someone to do
My lord,
business
may I say something?
earn and pay the revenue, please.
My
On a
lord-
lighter note, lordship.
My lord, the
But
so
lordship,
cause
kindly see.
notice.
Lordship, kindly see. Had it been this submission on that day, lordship could have.
Council.
Now, lordship, no, I understand.
Yeah,
Lordship,
at times you also will not have instruction.
lordship, kindly
Okay.
see. Lordship, then in that case, without paper book, lordship, kindly fix it on next week. We will argue it out, lordship. He is
All right.
protected this time. Because only short point, lordship,
All right.
I
We
will
have heard
demonstrate
the
before your lordship.
We have heard the learned advocates for the parties. On 28/4/2023, this court passed an interim order in this appeal, directing the appellant to pay a sum of rupees 607,850, and if such payment is made, the demand of payment of penalty was directed.
No, in that case, I'm sorry. To
directed
interject.
to remain stay. Further, the appellant was directed to deposit a further sum of rupees 25 lakhs, and if the appellant complies with the twin conditions, namely payment of 607,850 and 25 lakhs and 25,000,000, there was a direction to lift the attachment of the appellant's bank account. The appellant has now filed a supplementary affidavit contending that much earlier, that is prior to after the order was passed by the single bench and before the appeal was filed, a sum of rupees 3,98,09,291.85.
I'm sorry. Before the order of the single bench.
No, my lord.
Yes.
No.
Kindly see the
No.
date of the order.
has
17th
been-
March.
has been debited from the appellant's bank account. Therefore, the appellant pleads inability to pay the sum of rupees 25,000,000 as they are suffering from severe financial crisis. As it is seen that already a sum of more than rupees 3.9
Lordship,
crores
I am
has
not
already-
verified. Lordship, kindly allow me to verify at least in that.
3.98 crores has already been debited, the direction issued by this court directing the appellant to deposit a sum of rupees 25 lakhs, 25,000,000 stands set aside, and there will be a direction to the respondent department to lift the bank attachment which has been effected on the bank account/accounts of the appellant assessee. The appeal will be heard after 2 weeks. You give a date, and the respondent department is entitled to place necessary records to show as to whether the debit of more than rupees 3.98 crores was towards the subject liability or towards any other liability which was subsisting at the relevant time. List the matter on so and so date.
Well, may
Lordship, I
I
must
take
say,
2
this
minutes
is
of
a very
lordship?
harsh order on me.
My lord, I had a liability of
allow me 2 minutes, please.
I had a
Uninterrupted.
liability of 1.48 crores, my lord. Out of which, at the time of filing the return, although it was nil filed, but the tax was paid, my lord. Automatically, there is no interest, there is no penalty, as because penalty.
will
No, that Lordship will see.
Hold on.
The Lordship
My
in
lord.
that case, only one. Since Lordship has reviewed the order, modified the order, even without a formal application, Lordship, I have one small prayer. Protect my...
Matter is pending.
No, Lordship, I understand. Lordship has done an equitable thing. He should also do the business. Now, Lordship, can you protect me also? I have an attachment of the bank. I have some money due. So let him give me this 25 lakh by way of a bank guarantee at least. Lordship, he is a businessman. He has got a...
The wait, sir, please hear. The appellant is directed to furnish a bond in favor of the respondent department, undertaking to pay the deficit amount in the event the appellant is unsuccessful, either in this appeal or before any proceedings under the provisions of the relevant act. Full stop. The penalty which has been demanded shall remain stayed till the appeal is heard and disposed of. Give a date after. Next.
Serial number 4. Grateful lordship.
I'm obliged.
Yes. Appealing for the matters. Yes. Yes.
May it please your lordship. I appear in the intervention application, my lords, in this appeal filed by my learned friend, my lords.
Your lordship, in this matter, Mr. Raichandani and I, my lord, we appear for the applicants, my lord, in can number 2 of 2023, your lordship, wherein we are paying to be added as the appellants, your lordship. Appellant number 2.
They are praying for being added as an intervener, not appellants.
As an intervener, my lords, not as the appellant, because we, my lords, may just submit. My learned friend, Mr. Shah's client.
Your lordship is that let my appeal be heard. After that, my lord, your lordship can consider this intervention application, whether your lordship is willing to hear the intervener or not. But let the appeal be heard first, your lordship.
My lord, since so long the application is there, my lord, a liberty should be given to me to file a repeat. My lord, I have that instruction.
My lord,
from the
this
department.
matter was heard on
Department
16th of June, your lordship. On
My lord, your lordship. Your lordship,
My lord, was directed to my lord,
Today we can't hear the appeal.
Yes.
We need to fix a date for the appeal. Probably at that stage, we will consider your intervener. You remain.
Well, my lord, direction may be given to me to file a petition, my lord.
Because it's a hearing matter. It's a hearing matter. We can't do it today. In the
My
meantime,
lords, on the last occasion also, your lordship said directed my learned friend to file a response.
yes, we have heard the so and so. Since the appeal has to be heard finally, a date is required, has to be fixed for such hearing. Since an application has been filed in can number 1 of 2023 by third party to intervene in the proceedings, liberty is granted to the respondents to file their affidavit in opposition if they so desire. In the meantime,
Addition.
list the appeal, give a date sometime in September,
Can do.
sometime in September.
बोलो जाओ,
Okay?
सिद्दीक बोलो जाओ.
September.
You will see the diary and give.
I would request the Learned Counsel for the intervener, my lord, to serve me a copy. I appear for the state.
You please give copies,
My
sir,
lord, I shall do so immediately.
immediately. Next,
Serial number 5.
Great, sir.
yes.
My lord, this appeal is with a very limited scope, my lord.
Mhm.
My lord, the writ petition has been admitted. My writ petition has been admitted. And a conditional interim protection has been granted to me. I am aggrieved by this condition, my lord. Now, if I may read out from the impugned order, my lord, I have been directed to pay 20% of
Let
the
us see
demand.
let us see the order passed by the authority dismissing your appeal.
My lord, the dismissal is purely on the ground of a delay of 30 days.
30 days beyond the condonable period.
My lord. But my lord, I have substantiated it with medical
Medical
documents, my lord.
Let us see the order. But suppose he does not have power under the statute.
My lord, my only contention, my lord, is the total demand is about 1 crore 71 lakh rupees. Out of which total 1 crore 2 lakh is already at the disposal of the revenue, my lord.
You have recovered.
I have voluntarily paid the entire tax amount, which amounts to 71 lakh 23,536. And they have recovered an amount of 31 lakh 15,094. So, and also, we will also add to this the pre-deposit of 7 lakhs that I have made at the time of filing the
Let
appeal.
us see the order of the appellate authority.
My lord, page 54, my lord.
Page 54.
It is only an acknowledgement. Appeal is time barred under
Acknowledgement,
serial
my lord.
number 8, reason for rejection.
And page 55, my lord, is the medical document with which I have substantiated.
Serial number 8.
Serial number?
8, my lord. Reason for rejection, other reason, the appeal is time barred. Has the lordship got that? Page 54. Form GST APL 02.
No, it's not there.
My lord, running page number is 54.
This is the page number. Lord, this type of form.
That is form GSTR APL 01.
No, this is 02. APL 01 is the filing of the appeal. After that, my lord, just after that, 3 pages after that.
Appeal is barred.
Appeal is time barred. It is page number, my lord, in your lordship's copy.
56.
So it is 54 now.
And it was beyond the condonable.
It was not.
On what date the appeal was presented?
Appeal was filed on
31st
July 2022. Your lordship, kindly see serial number 2.
31st July 2022. When did the period of limitation expire? You give the dates.
6th July 2021 was the order passed by the adjudicating authority.
2021.
So 4 months from then.
31st of July.
No, 4 months from July 2021.
2021 is the limit.
August, September, October, November.
My lord, at that time, we were covered by the judgment of the Supreme Court. COVID judgment.
It was till February, subject to correction.
No,
March
2022.
March 2022.
So from then, my lord, 4 months, maybe about
April, May, June, July.
So if it is there, it is within 4 months.
But it was time barred, the calculation.
But then 1.2 crores has already been recovered.
My lord, if your lordship kindly sees the calculation, I'll tell your lordship, my lord, I leave it to entirely to your lordship. The calculation is already annexed. I do not know the page number will tally or not. Page 49 and 50. Order sheet, my lord, this is order sheet, part of the order sheet. There are 2 orders.
Required to pay the tax liability. 1 crore 99 lakhs 80,000.
But your lordship is looking at page
52 in our set. Internal page 2.
But order sheet, your lordship.
Yes. Next sheet,
Next page.
next paper.
Next page. The total
1
liability.
crore
if it is-
99 lakhs.
After all this deduction, no, my lord, as on date, my lord, the tax component comes to, if we add up both these amounts, it will be around 10, 100,000, 10,000 lakh, 10 lakh, 40 lakhs. 40 lakhs, 8,442. And the interest, if added up, it is 29 lakhs, 7,296, and penalty will be 71 lakhs, 23,536. It is entirely up to your lordship, my lord. The tax
Good.
component is 40 lakhs.
All right, where is document to show that 1.2 crores has been paid, my lord? In the writ petition, have you stated so?
Yes, my lord.
Oh, that has been deducted, my lord. Whatever it has been paid, if your lordship kindly sees the first page of that order sheet, it has been mentioned. The second page also,
My lord, I
as
have
the
given,
RTP has no cash balance in cash ledger and credit balance in interest and penalty head, hence the amount of those head could not be set off, but tax amount of is this and this is set off from credit ledger and cash ledger as found in the said ledgers, and the payment is successfully made with a payment reference number so and so. 15 lakhs 63,000, 15 lakhs 51,000, adding up it's around 31 lakhs 15,094. That is the amount which has been set off.
So we'll
my lord,
ask
I
them-
have given the calculation in page 3 of the writ petition, my lord. Page 3, I have given of the writ petition. That will be at running page number 21. My lord, this I have voluntarily deposited, my lord, by DRC 03 form, my lord, which are also annexed here. The CGST amount,
that is what the ground pleader has also shown.
the CGST amount, my lord, 35,61,768, and the same amount for SGST. That will add up to, my lord, 71 lakh 23,536. That covers the entire tax amount. On that, they have again recovered. Their recovery is to the tune of total 31 lakh 15,094.
Apart from this 71.
Apart from this 71. That's why it's adding up
So
to
this
1 crore.
page 21, the total comes to 71 lakhs 23,000. You just said page 21.
That is what we have paid.
What is
Page
the amount?
21.
71 lakhs.
Yes, my lord.
Now you tell the amount figure.
It comes at 71 lakhs 71,23,536.
536. Apart from that, they have recovered.
They have recovered 31,15,094.
094.
And we have deposited about 7 lakh odd rupees for filing that appeal also. So, my lord, my submission is that this conditional interim protection may be done away with, and
All
I
right,
may be
please
given
come.
the protection and the
This
petition may be.
intra-court appeal is directed against the order dated 13/12/2022 in WPA 26857 of 2022. The said writ petition was filed by the appellant challenging the order passed by the appellate authority under the provisions of the WBGST Act dated 31/8/2021, dismissing the appeal petition filed by the appellant on the ground that it was delayed by a period of 31 days. The learned single bench, while granting an interim order, has directed the appellant to pay 20% of the demand to be entitled to an order of interim stay. Aggrieved by such condition imposed while granting stay, the appellant has filed the present appeal. We have heard so and so. With the consent of the learned advocates on either side, the writ petition as well as the appeal are taken up for hearing and disposal. As could be seen from the order passed by the appellate authority, the appeal was not dismissed on the ground on merits, but on the ground it is time barred. Admittedly, the period of limitation would fall within the period during which the order of the Hon'ble Supreme Court was in operation, which granted benefit of which directed that the period while computing limitation for presenting appeals would stand excluded. Though it may be true that there may be a marginal delay thereafter also, as the appeal was presented on 31/7/2022, we find that the case on hand is a peculiar case where the facts can be considered so that the appellant is not non-suited on a technicality, but would have an opportunity to put forth the case on merits. The appellant has enclosed medical records of its proprietor or partner.
Partner, my lord.
Of the partner who had been managing the business, who had undergone, who had who had suffered certain ailments and was hospitalized. That apart, we note that already the appellant had voluntarily paid a sum of rupees 71,23,536 towards this tax liability under the provisions of the CGST Act and SGST Act. Over and above the said amount, the department has recovered a sum of rupees 31,15,094 from by setting off from the cash ledger, from the credit ledger and cash ledger on 29/6/2022. Apart from that, the appellant has also made a pre-deposit of more than rupees 7 lakhs while filing the statutory appeal. Thus, considering the peculiar facts and circumstances of the case, we are of the view that the appellate authority shall dispose of the appeal on merits, rather rejecting the appeal on the ground of limitation. For the above reasons, the writ petition as well as this appeal are allowed, and the order passed by the appellate authority dated 31/8/2022 is set aside, and the appeal stands restored to the file of the appellate authority, who shall decide the appeal on merits and in accordance with law, after affording an opportunity of personal hearing to the authorized representative of the appellant. This direction be complied with within a period of 3 months from the date of receipt of the server copy of this order. Next.
Serial number
Faithful.
6.
Your Lordship, I beg to appear on behalf of the appellants, which my advocate on record must be there in court with the affidavit of service.
We are able to hear you, sir, not able to see you.
Your Lordship, I just apologize.
No problem.
By some technical issue, my camera is not working, Your Lordship.
No issues, no issues.
Your Lordship, very short point involved. I have come challenging an assessment order passed under section 147, wherein Your Lordship, the only point involved is that without considering my reply under section 1 to the notice dated 142, they've passed the assessment order. Your Lordship, may kindly take up the assessment order at page 131.
Who will appear for the respondent? Income tax department, they have been served.
Yes, my lord, they have been served.
And who appeared before the single bench?
Your Lordship.
Dismissed at the admission stage.
Yes.
Yes, Your Lordship.
And somebody can, Arya, you can take notice. Or somebody, which is the jurisdiction?
Your Lordship, this is
Assessment officer.
Your Lordship, this is Bamboo Villa. Your Lordship, I will just indicate the jurisdictional office.
What is the challenge? 140 AD. 140 AD challenge.
The board number 62.
What is the challenge? Yes. Standing councils from the department.
Where is the notice under 142(1)?
Your Lordship will find the first notice is at page 37, 20th of October 2022.
37.
37, Your Lordship. That I have replied to, and that has been taken note of in the assessment order. Thereafter, Your Lordship, though this was a part reply, thereafter they had again issued a notice on 11th of January 2023 that Your Lordship will find at page 96. Now, Your Lordship, I have also replied to this, and Your Lordship will find it from page 99, the acknowledgement receipt. Your Lordship will find at page 99, annexure P4, e-proceedings response acknowledgement, notice issue date 11th of January 2023. And at the very bottom, Your Lordship will find the reply letter.
Your Lordship, the letter is annexed at page 101. Your Lordship, though I have replied to this notice, if Your Lordship kindly takes up the assessment order at page 131. And Your Lordship may kindly turn over to page 132. Details of opportunity given. Your Lordship will find the third row, 142.1, 11 January 2023 notice. Your Lordship, response not received.
Not received. That is wrong.
Yes, Your Lordship. That is the only ground that the assessment order has been passed in violation of principles of natural justice. Your Lordship, the reply ought to have been considered before passing the assessment order.
May take instruction and come back.
We'll send it back.
Because the factual aspect, he is saying the notice has been not served. This is factual. If I show your Lordship that the submission is wrong, the notice has been served.
No, the e-acknowledgement is there.
But the system is
page 99.
The system is that the notice has been sent through email also in the portal also.
Yes.
Now the factual thing that without verification that whether he has received the notice by
No, he has
registered
received, the notice was issued on 11th January. It's dated 11th January. He has submitted his response on 16th January. Please take page 99. Yes.
Page 99.
January.
But now, you have to kindly see page 96. But here the notice says, produce or cause to be produced the account and document call for as per annexure on or before 16/1/2023, 10:48 a.m.
The 24th January.
All right, then you get instruction.
24th January 23.
Now, Mr. Dutt saying it is sent on 24th January.
The Lordship will take page
Yes.
99 at the top or right hand side. Your Lordship will see the last last 6 digits. That is 24th of January 2023.
But that is the
That
date
is
of
the date of
submission.
submission.
That is the date of submission. The body is date of submission.
The date given for submission, due date for submission is
16
16th of
January.
But the date of submission is 24th of January 23.
That is 99 page 99.
But the assessment order was passed on 3rd of February. By then it was already uploaded.
May I subject to correction here? The system is that when the SSC are directed to serve the reply, thereafter the time when the time expired, the portal automatically closed. Then the assessing officer, if he served the reply after that time, the assessing officer not able to show his reply. See his reply. That is system is there.
But the assessee will be given an acknowledgement.
Yes, because he is submitting in the online portal, but the assessing officer not able to show his submission. Maybe assessment order passed after 7 days.
Your Lordship, may I only say this? Even if
we will take instruction in this matter, then we will submit.
Yes, what is your submission, Mr. Kothari?
Your Lordship, I was only saying, even if I was time barred, Your Lordship, the order ought to have recorded that I have submitted a response and that was not considered because it was time barred. But the order.
No, what Mr. Bhattacharya says is
Yes,
that
Your Lordship.
you have uploaded, but that
Yes,
will
Your Lordship.
reflect in the screen of the assessing
Faceless assessing officer, because
We don't
who is making the assessment after the due date
Alright.
of submission, that is
we have heard so and so. This appeal is directed against an order passed in the writ petition which was dismissed at the admission stage. Since certain factual clarification is required, we have requested Mr. Soman Bhattacharya,
and led by Mr.
Mr. Ariyak Dutt and Mr. Soman Bhattacharya, standing counsels, to accept notice on behalf of the respondent department and their appearance be regularized by the department. The appellant's case is that they filed a e-response to the notice dated 11th January 2023 and the same was uploaded and an e-acknowledgement has already also been generated. However, in the assessment order dated 3/2/2023, it is shown that no response was received from the assessee, which in the submission of the learned advocate for the appellant is factually incorrect. The learned standing counsel for the department is directed to get written instructions on this aspect and place the same before this court. List the matter under the same caption on when do you want it? Next Wednesday.
Next Wednesday, no, not Wednesday.
Not,
Friday.
next Friday.
Yes.
Next Friday. In the meantime, don't do anything.
The assessment order has been passed, my lord.
Let us
Even if we take the point before the CIT appeal.
All right, let us see.
Grateful, Your Lordship.
Yes. Same position, no?
May it please, Your Lordship.
Yes.
My lord, I am appearing for the
Sir, one
appellant in the
line
matter.
you online had print the name of Mr. Aryagda and Mr. Soman Bhattacharya in the castle list.
Has it been served?
Aryag.
Sir, I am here.
Yes.
May it please, Your Lordship.
2 weeks to file supplementary affidavit.
Lord, we have the supplement. We have served, my lord. May I have my lord's kind leave to file the supplementary affidavit? Lord, may I also have my lord's leave to file the affidavit of service? 2 copies? 2 copies. Lord, the impugned order, lordships will find at page 30 of the state petition, my lord. Give us 2 judgments. Supreme Court.
Page 36. Impugned order. Page.
My lord, page 30 of the state petition, my lord.
30.
30, my lord.
No, that is the order in the writ petition.
The order in the writ petition. This is, my lord, under challenge in the present appeal.
And what was the challenge in the writ petition?
Challenge was, my lord, the illegal search and seizure, which, my lord, was perpetrated by the department. But may I encapsulate the facts here? That the petitioner before your lordship, my lord, is engaged in the import and export of food and non-food items. My lord, they carry out their business from 310 CR Avenue. That's the, my lord, place where they have their principal place of business. My lord, there was some renovation work which was to be, my lord, carried on in this premises. Temporarily, my lord, they shifted their work at an additional place of business. My lord, this was Thakurdas Chakraborty Lane. It's a separate premises where they were not carrying out the work.
Approved by the department?
My lord, it was to be approved. They had not uploaded it.
Then they will not recognize.
They will not. My lord, but that is not an issue, my lord. It is not about the registration dispute. Here, what has happened, my lord, a search and seizure was, my lord, carried out on both the premises. On 11th of January 2023, when 25 to 30 officers of the department, my lord, carried out a sudden search and seizure. My lord, here, I'm not going into the details at all. My case before, my lord, this honorable court is twofold. They have seized cash, which is an absolutely illegal act because, my lord, here, admittedly, cash is not the stock in trade of the petitioner. The very recent judgment I could, my lord, find today. This was, my lord.
Now, what to see? You wanted some interim order. What's the interim order which can be granted in a writ petition?
Lord, interim order.
And you want a refund of 12.85 lakhs which was seized.
Seizure, yes, that is the interim relief I'm praying for because, my lord, they have seized.
No, that can't be.
My lord, may I indicate?
Let them file their affidavit in the writ petition. We'll expedite the writ petition.
My lord, affidavits have been filed.
We have filed the affidavit.
May I indicate 2 things before I, my lord, only 2 things.
There is no scope.
Lord, may I only indicate this, if your lordships kindly permit me.
At the appropriate time, you challenge the search.
My lord, only the reason, I understand what is falling from your lordship. I will not press much. My lord, only this. If your lordships are pleased to take up 2 pages. One, my lord, page 86 of the state petition. And my lord, apropos, my lord, page 86. But page 35 of the supplementary affidavit. I want to indicate this, my lord, what they are doing.
You cooperate, sir. You cooperate.
Definitely we will, my lord. Definitely we will.
Page 35.
We're at page 35 of the supplementary affidavit and
Yes.
page 86 of the stay petition.
Yes.
Your Lordship will find page 86 of the stay petition. It's a order of seizure under 139(2). There was no INS 01 which was ever given. We have been praying for that. It was given in court, which we had the chance to glance upon, and we came to learn it is not for the same premises. Now, my lord, kindly see, very interesting. Page 35 and 86 are supposedly the same document. My lord, kindly see page 86, GSTN number is not the GSTN number of Rajesh Shah. It's not the GSTN number of Rajesh Shah. Now, kindly, my lord, see at page 88 of the stay petition and page 37 of the supplementary. That apparent discrepancy. Page 88, your lordship will find this is supposedly the same document. One has a stamp, one has a lot of things written. I'm not even going into, my lord, what is written. One is provided to us, my lord, other is what they are relying on. Absolutely different documents.
Take advantage of it at the appropriate time.
At the time of hearing, I understand that, my lord.
No, I don't know whether it's at the time of hearing, but anyway.
My lord, also, I am only praying for this interim relief, my lord, based on a very recent decision which says if it is stock in trade, if the money is stock in trade, yes, they can seize it.
It's too premature, sir.
If the, my lord, because it is an admitted position in my very humble submission that it is.
Let the affidavit be filed and then you argue. This intra-court appeal is against an order dated 13/3/2023 in WPA 2561 of 2023. By the said order, the learned writ court has entertained the writ petition and directed affidavit to be filed by the respondent. We are informed that the affidavit has already been filed by the respondent. Considering the interim relief sought for in the writ petition, we find that the learned single bench was right in observing that there is no scope for granting any interim relief during the pendency of the writ petition, when the challenge to in the writ petition is to a search which was conducted by the respondents in the place of businesses of the appellant. Furthermore, there is also a prayer for prayer seeking refund of the cash which has been seized during the search operation. These issues cannot be adjudicated at an interim stage, and the reliefs interim reliefs prayed for it have to be acceded to. It would tantamount to allowing the writ petition at an interim stage, which is impermissible under law. Therefore, there is no scope for interference with the order passed by the learned single bench. Accordingly, the appeal is dismissed. Let the writ petition be listed before the appropriate learned single bench on the date which has been fixed in the impugned order. Next.
May it be recorded, my lord, the other prayer was not for returning of, my lord, the computers and the.
What are you going to do? It's all obsolete.
Very deeply obliged.
Next. Even if they return it, they'll remove the hard disk.
My lord. Very deeply obliged.
Yes, sir.
My lord, I am appearing for the appellants.
You are challenged the show cause notice.
Yes.
And in the meantime, they pass the final order.
Yes.
And the learned judge says, upload the final order, you file an appeal.
Yes.
And there is no reply given to the show cause notice.
Yes, reply given.
But reply not considered.
That is not my point, Lordship. If you hear me, allow me just 5 minutes, otherwise 2 minutes.
No. You take your time.
It is obviously the show cause there so many matters challenged, and Lordship has passed in favor of the assessor, sometimes in favor of the department. But my case is little bit different, and it's a very important 3 questions of law I will place. Just background is that here the appellant is a manufacturer of tarpaulin. In February 2019, state officers of the Bureau of Investigation, they visited, and they, according to them, they have ascertained some stock, and they allege that is a shortage of stock. Fine.
Thereafter, this November 2021, show cause notice was issued. Immediately, I filed one writ petition challenging the search and seizure. After in January 22, I filed another writ petition challenging the show cause notice. Fine. That matter, when came first, page 34. Kindly look at this. Single judge passed an order, page 34. 36, Lordship, stay petition. And two documents I will read thereafter. Page 36. This is order that is 4th March 21.
4th February.
4th March 21. Lordship got it?
4th April, February.
Page 36.
February.
4th February, sorry. 4th February 21. Very small order. Second paragraph. After hearing the parties and considering the materials on record, I find that the matters can be more effectively adjudicated after calling for affidavits. Accordingly, affidavit direction filed that much. Liberty to mention inclusion in the list. Hearing 6 weeks. That much the affidavit direction is there. Thereafter, and there is another direction here. It is important, page 37. The hearing in terms of the notice dated so and so scheduled to be held on 9th February shall take place. The petitioner should attend such hearing. The authority, after hearing the petitioner, appears and shall prepare the necessary order, and such order will be made published and communicated only after obtaining the leave from this court. Next, that is the order against which I page 34. Here, after her so and so, it appears on the record this petition was filed against the impugned or show cause notice dated November 2020 by the order of this court, 4th February 21. The respondent's authority concerned were restrained from publishing and communicating the final adjudication order on the basis of the impugned show cause notice and notices hearing without this show cause. The matter has come up for the list so and so. I am not troubling your lordship. Next, considering the submission of the parties and taking note of developments takes place during the pendency of the petition, this petitioner being so and so is disposed of, directing the petitioner authority concerned to publish the aforesaid adjudication order dated March 21. And thereafter, this I am not, if they are aggrieved, they file appeal. That's much. Now I have come before your lordship. I have not challenged the three basic points in the writ petition. One, this show cause notice was issued without the determination of the levy of the tax. They have not power to levy the tax under section 9(1) of the WBGST Act without determination of the place of supply. The basic point in the GST matter, lordship award, that is a destination-based tax. If you cannot determine the destination, you cannot demand the tax. This is my first, I'm just giving the gist of my submission. First, there is a violation of the section and the constitution also. I will come. Second point is that the search was conducted by the Bureau of Investigation. I have taken a point that Bureau of Investigation, there is no appointment of the Bureau of Investigation under the GST Act. Bureau of Investigation was created under the West Bengal VAT Act. Number one. Number two, even after enactment of the WBGST Act, 2019, Governor has given their power by notifications. That means they are still in the VAT Act. Number three.
Transition provisions are there, sir. Whatever has been done automatically, it will. In fact, we considered one such matter where they said there is no power for the Bureau of Investigation to investigate, etc. We have rendered a decision, it is permissible.
I'm not, I'll take up this matter. Third, and even that, Lordship, Bureau of Investigation point is that Bureau of Investigation Commissioner has given some jurisdictional power. Lordship, I will show that still governor is controlling, and whatever the appointment in the GST Act, all this done by the governor, not the commissioner. Commissioner has the power to allocate the service and that much. After that, commissioner cannot do. This is my second point. Third is that Section 67, there is a power for search and seizure. They have not followed the methods. So I will give, if your Lordship allow me, first point I will show how this violation of the levy under the Act. If there's a violation, so cause an issue without jurisdiction. Lordship, I will give you just a compilation of the few sections I will show. I have prepared a small compilation of the provisions of the law.
In the writ petition, affidavit was filed.
Lordship, affidavit was not filed. Lordship.
Now, where is the order, adjudication order?
Order is that
190, my lord.
190.
190.
196.
Oh, my lord, I tender my apology, my lord. It is 257. 257. 257.
In these points, Commissioner in the adjudication order that was not taken. How can they decide this jurisdiction that without determination of the place of the rule violation of Rule 9(1)? They cannot. And if my respect to submission, when these basic points are taken, Honorable single judge should have entertained and should have heard this matter on the basis of affidavit.
No. When the first order was passed, that is in page 36, the court said, yes, we have to consider, but simultaneously allowed the authority to proceed. So you should raise this jurisdictional issue before the authority in your reply to the show cause notice. But the points which you have page 259.
Yes.
This is where not 259. Where is the
257?
257. Where is the gist of your reply?
We have not discussed, frankly speaking. He has given his finding. Lordship, when the Lordship has passed so many decisions, even in the Chennai, I don't want to place all these things so much, Lordship ever. When they have no power to demand the tax without determination of the place of supply. So show cause notice falls.
Where is your reply to the show cause notice?
Show cause notice.
Reply.
Yes. Page 194. Page 190 starts from show cause notice, and what point I'm submitting, that is page 194. Only one sentence.
Where is your reply to the show cause notice?
Lordship, only when you have opened this show cause notice, Lordship would please to see one sentence.
No, that is correct, sir. As per the order in page 36, you are required to participate. If you see page 36.
Page 36.
Hearing 37. Hearing in terms of the notice dated 1st February, scheduled to be held on 9th February shall take place. The petitioner should attend such hearing.
Yes.
Authority after hearing, if petitioner appears, shall prepare the necessary order, but such order will be made published and communicated only after obtaining leave. So therefore, you are bound to participate in the adjudication. And where is your written reply to the allegations in the show cause?
Lordship, this is not filed here, but copy is with me. If your Lordship allow me, I will. Otherwise, I will.
You show that reply.
But all that. Lordship, above all, when they have once, I am saying, my lord, my submission is only very simple, Lordship. If they are not determining the place of supply, they cannot demand. Point is that if this is a clandestine removal, charge is clandestine removal. When they are charging, they have to determine where these goods have gone. Suppose these goods have gone to the Maharashtra. Now that share will get this, Maharashtra government will demand this tax. So that is a preliminary point of this case. And that is their admitting. Page 194. That we have taken in the appeal writ petition, not seriously I have taken in the reply. The reply was drafted by the consultant, he is not so much about the position. And I have, Bureau of Investigation, I have said that he has given this, quoted the section out, nothing more. Page 266. My first point, I have taken in reply, page 22. 22. Para 2, 5.27. 5.27. That without determination of place of supply, you cannot demand the tax.
They have dealt with.
Lordship, only one sentence I'm showing, Lordship. Kindly look at page
No,
22.
definitely, it is not a pure question of law. It's a mixed question of fact and law.
No, there is
Sir,
no pure question of law. Only one sentence, if Lordship.
page.
You prefer an appeal. You prefer an appeal against this.
Lordship, I will carry out your Lordship's order, but Lordship allow me. If the place of supply is not determined, tax cannot sustain.
But that they have given certain reasons.
No. In the order, no.
You can't read this order in isolation. This order is running to almost 16 pages. The adjudication order passed by the Deputy Commissioner. He has dealt with this Bureau of Investigation, etc. All these points.
This point, basic point, he has not ignored, he overlooked. That is the reason.
That's a good ground for appeal.
Lordship, if
we will extend the time for filing an appeal.
That has to be.
What about pre-deposit? You would have already they would have recovered.
That is a standard, whatever 10% it will deposit. And Lordship, kindly, if the Lordship read jurisdiction, I am here. If the place of supply is not determined by the state authority, can they collect the tax? If the question is yes, I have no case. If the
No, we are not saying that you have no.
I am asking myself.
But you will may have a good case before the appellate authority.
They cannot. They cannot. They are not empowered. This is a jurisdiction. That is the
They can definitely they can. The appellate authority can examine.
And Bureau of Investigation power, how they will decide? The Bureau, they are the appellate authority. I have taken this point, nothing, no finding. Please, what I will, it is a futile exercise of the appellate authority. He has
We will observe that he will decide the questions of law which you have been framed, which you have said. GST is a destination-based tax, and the demand of 74.5.
I have prepared a question of law. I have for your Lordship's pleasure, I have prepared a question of law.
In page 8 of your memorandum, it is there. Page 8.
But that was not properly done. I have prepared it more categorically to help to assist my lords.
This intra-court appeal is directed against the order dated so-and-so and WP number so-and-so. By the said order, the learned writ court dismissed the writ petition and relegated the petitioner to file an appeal against the order of adjudication passed by the respondent authority. Agreed by such order, the appeal has this appeal has been filed. We have elaborately heard the learned advocate for the appellant and the learned government counsel appearing for the respondent authority. Initially, when the writ petition was entertained, an order was passed on 4/2/2021, directing affidavit to be filed by the respondents in the writ petition. However, the court did not defer the adjudication of the show cause notice, but directed the appellant to participate in the hearing so that the adjudicating authority can proceed with the adjudication process and pass an order. However, there was an order, not publish the order without the leave of the court. In terms of the directions issued by the learned single bench, in its order dated 4/2/2021, the appellant had participated in the hearing and the authority has passed the adjudication order dated 9/3/2021. This order came to be passed during the pendency of the writ petition, and the learned writ court directed the appellant to file a statutory appeal. The learned counsel appearing for the appellant would submit that several questions of law which were raised in the reply to the show cause notice dated 9/1/2021 has not been considered by the adjudicating authority and has been ignored. The appellant has raised the following questions, which according to the appellant ought to have been decided by the adjudicating authority and precise. And since these are questions of law, the learned writ court ought to have decided the question instead of relegating the appellant to the statutory, to avail the statutory appellate remedy. So these questions you have to extract. The questions, the questions which have been raised before this court are as hereunder. Full stop. 1 to 5. After considering the submissions made by the learned advocate for the appellant and perusing the questions of law which have been formulated, we find that the questions framed are not cannot be adjudicated without considering the factual position. In other words, the adjudication would require a examination into facts for the purpose of answering the questions of law which have been framed by the appellant. Therefore, it is not a pure and simple, pure question of law which has to be decided. But what is required to be decided is a mixed question of fact and law. Therefore, we are of the view that the appellant should avail the statutory appellate remedy, which is not only effective as well as efficacious. Full stop. Needless to state that the appellate authority shall consider the questions which have been framed by the appellant before this court and take note of the relevant facts and then give a finding on such questions which are urged by the appellant. For the above reason, we are not inclined to interfere with the order passed by the learned single bench, and the appeal stands disposed of by directing the appellant to file a statutory appeal within a period of 30 days from the date of receipt of the proper copy of this order. In the said appeal petition, the appellant shall raise the 5 questions which have been raised before this court, which shall be considered by the appellate authority after taking note of the facts of the case and the other submissions which the appellant may make on the merits of the matter, and pass a reasoned order on merits and in accordance disposed of.
Serial number 9. Take the other points also.
Yes, all on merits also.
On merits. And time limit any?
30 days to file.
30 days. And your lordship pleasure to extend a little bit?
With 45 days.
I'm grateful.
Next.
Item number 9, my lord, I am led by Mr. Ajay Krishna.
I appear for the appellant, my lord.
Of India.
The response number 6. My lord, my challenge in the my lord writ petition was to a show cause notice, which my lord was issued in 2022, but was pertaining to my lord duty drawback recovery of my lord 2007 and 8 benefit, which was granted. My lord, my short point before the writ court was that the initiation of this proceeding by issuing the show cause barred by limitation. I am covered by your lordship's judgment. I am covered by other my lord authorities, my lord. This aspect was not at all considered by the learned trial court. And my lord, it was held that because it was the observation of CAG was that you have to proceed against this appellant, therefore you have to comply with it. And the objection with regard to jurisdictional error was neither considered by the trial, was not considered by the trial court. Now it has also, my lord, after the trial court's order immediately being agreed, my lord, we filed this appeal and we, my lord, served also the appeal. I must bring it to your lordship's notice that in compliance with the order of the, my lord, single judge, the authority has also, my lord, passed an order parroting the language of the show cause notice and only, my lord, saying without providing any reason why, my lord, or how, my lord, the authority has jurisdiction now to, my lord, decide on this. Now this is the, my lord, question to be decided in the appeal, my lord. I have prepared a supplementary affidavit, my lord, bringing on record this consequential order which was passed pursuant to, my lord, the learned single judge's order. My lord, kindly grants me liberty to file it, my lord. Now, my lord, kindly, if your lordship takes the show cause notice first, my lord, before I take your lordship to the impugned order. My lord, page 100, my lord, is the show cause notice.
But why did you not immediately come to court? The court says after 1 year you are challenging the show cause notice.
We were, my lord, notices were issued. We had, my lord, replied. In fact, we had also said, my lord, because of a fire, my lord, documents are lost. I have annexed documents to my writ petition. Nothing was considered.
In the reply, you could have raised this as your preliminary objection, saying that the show cause notice is barred by time.
My lord, that is the finding.
Very open to adjudicate on his own jurisdiction.
I understand what is falling from the bench, my lord. But my lord, lordship will kindly appreciate this, my lord. If it is a jurisdictional error, Even if, my lord, that point is not taken in a reply, I bring it to the notice of the court that this initiation of the, my lord, proceeding by issuing the show cause notice itself is a jurisdictional error. My lord, in my humble submission, possibly, my lord, the learned single judge should have, my lord, decided on the point. I could have understood, my lord, that this issue of jurisdiction was held against my client and I was sent back to the authority to have an adjudication on merits. That was not done by the learned single judge. My lord, the authority also does not consider that, my lord, because I had taken this as a ground in the writ petition. I served them the appeal, taking it as a ground in my appeal also. Not discussed even a single line, my lord, on this issue, my lord. My lord, page 100 is the, my lord, show cause notice, my lord.
So it was based on CAG report.
Only, my lord, it was based on CAG report, which was, my lord, of 2013. My lord, CAG report pertaining to a benefit of duty drawback of 2007-8 of 2013 considered in 2022 by the adjudicating authority while issuing a show cause. There itself, my lord, there was a delay of 9 years. But if I take it from show cause, no, my lord, the benefit when I...
Where is your written submissions dated 8th February 2023? That is referred to by in this final order. You could have raised this point before him. 8th February 2023.
Yes, my lord.
That is your written submissions.
My lord, kindly takes the, my lord, stay petition 109. I must be very candid. It's not very happily, my lord, worded, my lord, reply. I know my lord, drawbacks here, my lord, so far as the replies are concerned. But I am, my lord, trying to urge a point of law, whether, my lord, the writ court, my lord, as a matter of fact, ought to have considered this jurisdictional issue or not.
It can relegate it. The
My
matter
lord, that was not relegated also. My lord, kindly sees the learned single judge's order. This issue was not discussed. It was avoided, my lord, with deepest of respect, my lord.
My lord,
My lord, may I just rely on one?
My lord, pursuant to the direction of the Honorable Court, my lord, the respondent already had passed the order in original, my lord. My lord, kindly come
Yes,
to...
they have given it as a...
Yeah, my lord, kindly
5th of
come to
June.
page 9.
Page
my
9
lord.
of the supplement.
My lord, and there is a, my lord, alternative remedy also, my lord. If they are agree with this order, my lord.
But this issue was not adjudicated. You are not acting on your own. Because you are, according to the zonal officer or deputy development commissioner, his hands are tied because CAG report. But he raises a crucial point, saying that though there may be a CAG report, it is of the year 2013. And on the date when the show cause notice was issued, it was barred by time. Whereas under the aforesaid circumstances, this office has to comply the direction of CAG. Therefore, the request of the noticee to drop is not acceptable.
It is only, this is the reason, my lord.
He is afraid of CAG, sir. What to do?
It appears so, my lord.
We will send it back to him. Let him decide the jurisdiction.
Particularly with regard to, my lord, jurisdiction.
Yes, that will be better. This intra-court appeal.
My lord, there was only one decision where, my lord, court had intervened at this stage and my lord said that it is absolutely beyond limitation. And in fact, lordship had also, my lord, delivered sitting, my lord, in the division bench.
We have refused to do this way and that way. Intra-court appeal by the appellant is directed against the order dated 10th April 2023 in WP 6677 of 2023. The said writ petition was filed challenging a show cause notice issued by the respondent authority dated 16th March 2022, namely the Deputy Development Commissioner, Falta Special Economic Zone, Kolkata, Government of India, Ministry of Commerce. Sorry, by the Zonal Deputy Commissioner, correct?
My lord, it's Zonal Development Commissioner and Adjudicating Authority.
Zonal Development Commissioner, Falta Special Economic Zone, dated 16th March 2022. During the pendency of the writ petition, the authority proceeded with the adjudication of the show cause notice. And when the matter was heard on 10/4/2023, submission was made by Mr. Chatterjee Leonard, senior advocate appearing for the department, that the adjudicating authority is to pass the order in original shortly. And this taking out of this, the learned writ court directed the authority to pass a final order and leaving it open to the appellant to seek appropriate remedy against such an order in accordance with law. The learned advocate appearing for the appellant contended that the jurisdictional issue which was raised in the writ petition was not at all taken into consideration and the appellant had specifically contended that there is a gross delay in issuance of the show cause notice dated 16th March 2022 as the report of the Comptroller and Auditor General within bracket CAG has made certain is purported to have made certain comments in the audit report which was drawn in the year 2013 and therefore the show cause notice is hopelessly barred by limitation. It is no doubt true such such contention was raised in the writ petition and has also been canvassed before this court in the present appeal. However, in the reply to the show cause notice, the said point has not been specifically canvassed by the appellant. Be that as it may, the question as to jurisdiction being a question of law can be permitted to be raised by the assessee at any given point of time. And there is no bar for the assessee from raising the issue at any stage of the proceedings. In any event, the jurisdictional issue cannot be decided in a writ proceedings, dehorse adjudication into facts, much of which are being disputed by both parties. Therefore, the appropriate procedure would be for the adjudicating authority to rule on its jurisdiction. However, this was not done by the adjudicating authority while passing the order on original dated 5/6/2023, since it appears that it was not specifically pleaded in the reply to the show cause notice dated 16th March. However, to be noted that such as ground has been specifically raised in the writ petition and admittedly the adjudication was done during the pendency of the writ petition and that it
final order was passed, my lord, after my lord the trial court's order, the learned single judge's order.
I am adjudication sorry
And
done during the pendency of the writ petition and the final order was passed order in original was passed much after the order was passed in the writ petition. Therefore, in all fairness, the adjudicating authority ought to have decided the jurisdictional issue. Therefore, we are of the view that the matter requires to be reconsidered by the authority, especially with regard to the jurisdictional point and raised by the appellant as well as the other points that may be canvassed by the appellant during the adjudication proceedings. For the above reasons, the appeal and the writ petitions are allowed and the order in original dated 5/6/2023 is set aside and the matter is remanded back to the Zonal Development Commissioner, Falta Special Economic Zone, the second respondent for fresh consideration of the matter. The appellant is directed to file an additional reply to the show cause notice within a period of 10 days from the date of receipt of the server copy of this order. On receipt of the additional reply, the second respondent shall fix a date for personal hearing in which the authorized representative of the appellant shall be afforded an opportunity to make their submissions. And after hearing the submissions of the on behalf of the appellant, the second respondent shall pass fresh orders on merits and in accordance with law. Needless to state that the second respondent should specifically decide the jurisdictional issue as first among the several issues which may be required to be decided during the adjudication.
I'm grateful, my lord. Lordship is also setting aside the learned single judge's order because there
Yes.
are certain observations.
Writ petition is allowed, appeal is allowed, order set aside.
I'm grateful, my lord.
Grateful, my lord.
Serial number 10.
But I beg to appear for that.
Limitation, 7 days,
2 days time given.
2 days only given.
My lord,
Learned judge says you are bogus dealer.
no, my lord. 2 days time given, my lord, and law says minimum 7 days and maximum 30 days. And your lordship held in the case of Girdhal, Gopal, Dalmia and other cases that on clear 7 days time should be given. I submitted reply due to paucity of time. Only bank statement I could not submit, my lord. And alleged material not supplied, and AO should make the inquiry on. Law says and CBDT instruction 22nd August 2022 also says. But here depends on the inside portal, my lord. And they did not consider the reply. And in the order written that hearing was fixed on such and such date. But in the show cause notice written, no. The reply was the response submitted within this date, my lord. And my lord, order passed, my lord, without giving hearing, my lord. My lord, kindly see, my lord, first show cause notice at page 69, my lord. In para 3, my lord, the reply should be submitted before 28 March 2022, my lord. And my lord, within 28 March 2022, but in the order says then our hearing was fixed on Ato. I'm showing your lordship. And my lord, next page 70, my lord. The credible information has been received from the inside portal, my lord. CBDT instruction and also section says that AO has to verify the information uploaded in the portal. I will show your lordship the notification CBDT instruction, my lord. And my lord, next, my lord, kindly page order at page 92, my lord.
He says page 93, 1, 2, 3, 4th paragraph.
Yes, my lord. 4th paragraph says that SSC had fixed for hearing, my lord, but that was not fixed for hearing, my lord. And second page, next para, my lord, that in response to notice 148 ADB, dated as such, the SSC has furnished information which shows data transaction 38 lakhs.29. This is not correct because in my reply, I have stated that my transaction is 55 lakh, which is tallied with the show cause notice. Kindly see, my lord, my reply at page, reply, my lord, 73. Starts from 73, my lord. And operative part at ledger at, my lord, 79 to 80, my lord. I have annexed the ledger and other all documents, but due to paucity of time, I could not attach the bank statement. That also admitted in the order, my lord. 79 to 80.
He could have issued a notice and asked him to come up with the bank statement.
Lord, your lordship kindly see the act of the assessing. Your lordship kindly see the notice has been served under section 148 AB in the month of March 2022.
Notice is dated 21/3.
21/3, therefore order is passed 6/4/2022. Thereafter, SSC is silent. 1 year SSC kept silent. Thereafter, when the notice has been served under section 143(2), he suddenly came up and filed the petition and saying that this point has not been done by the assessing officer after 1 year. Even he could take this point after pass the 148 AD order in the month of April 2022. The notice under section 148 AD merges with the notice under section 143, 142(1). After the filing reply under section 142(1) in the month of April 2023, he suddenly came to the writ court. And not only that, he made submission in his reply. he has categorically said that this, yes, I have made transaction with the Rajbot company. Now, the 93 lakhs or 56 lakhs, that is a pure question of evidence that will be deciding by the assessing officer. And same pretext, your lordship kindly see the order of Punjab and Haryana High Court affirmed by the Honorable Supreme Court in the case of Anshul Jain. Your lordship kindly see. Every
they are also silent. They are also
No,
silent.
no, this page 102 is the notice under 143(2).
Yes, my lord. They are also silent, my lord, because from
And
last.
you have enclosed the reply.
Yes, my lord.
And where is your, what is the name of the assessee? Ashish Kumar
Kanodia. My lord, in similar circumstances, similar cases, my lord.
But then contact also has to be seen, no? You have not been aggrieved. If you had aggrieved by the 148 AD order, immediately you could have challenged it. But thereafter, it's almost 1 year.
My lord, it was not known, my lord, by the SSC, because after receiving the notice, they are also silent from 1 year, my lord. After 1 year, they issued the 142 one notice. They could have noticed issued the notice.
Now you do one thing.
My lord.
You produce a bank statement in response to the 143(2) notice. They will afford you an opportunity. You produce and substantiate.
Yes. In the similar case, my lord, Rajesh Kumar Agarwal, my lord, your lordship restored the matter with the 148
That is
AB.
correct, but here the matter has gone
and
to the
similar
next
situation,
stage.
last Wednesday, in the matter of Suhas Agarwal, your lordship dismissed the appeal.
My lord, may I submit your lordship order, my lord, Rajesh Agarwal?
Correct, sir.
Similar case, my lord. Similar
91 of 2023, my lord.
Here it has crossed, Mr. Kumar, it has crossed that stage. It has traveled up to 143(2) stage.
Yes, my lord.
And the notice was issued on 15th March 2023. Now, are we to test the correctness of a 148 AB notice issued on 21st March 2022?
My lord, kindly see para 5 your lordship or similar case, similar circumstances. After 1 year, my lord.
5 minutes, I have handed over the judgment.
After 1 year, my lord, final order passed, 147 order. In that case, similar facts and circumstances, your lordship restored in the 148 AB order.
Point of this limitation cannot not taken, my lord, because this is stall of the assessment proceedings. After 1 year, suddenly assessee come and says that this is wrong.
And the basis of the proceedings, my lord, kindly see, my lord, CVDT instruction, my lord. CVDT instruction, my lord, by 22 August, my lord.
He can, but the point is that he can take the point in the month of April 2022.
Para 2.7, my lord, and para 3.1, my lord.
Came before this Hon'ble Court, April 2023.
That is it. Writ petition filed in April 23.
Yes, my lord.
That is after 143(2) notice.
Yes, he has submitted document in accordance with the notice of 142(1). You kindly see, he has annexed.
Page.
I'm not showing the lordship, my lord. The notice is, my lord,
142 notice.
Just a minute.
15 March.
15 March.
Page 98.
Page 98, yes. Correct. But he has filed the reply on one page reply on 104.
No, already
on 16 March
uploaded
2023.
all the documents, but not
submission against your notice, correctly. And here also, lordship, he has not annexed the bank statement.
No,
Lordship, kindly see the copy of audited report, copy of balance sheet, copy of income tax return, ledger copy of Rajbot trade, ledger copy of stock item. He has not annexed the bank statement. Here also.
If the
page 104. Even 16th March 2023, learned friend is saying in the paucity of time, in the March of 2022, I am not submitted the bank statement. Here, after 1 year, he also not submitted the bank statement.
My lord, when the initiation base is wrong, my lord, base is illegal, subsequent all, my lord.
That we will consider. This intra-court appeal is directed against order dated so-and-so in WP number so-and-so. The petitioner had challenged the order passed by the respondent assessing officer under section 148 capital A within bracket D of the Income Tax Act 90 Act. The appellant was unsuccessful in his challenge, resulting in the present appeal. The learned advocate would vehemently contend that the very initiation of the reopening proceedings by issuance of notice under section 148 capital A within bracket small b of the Act by notice dated 21/3/2022 is vitiated in as much as 7 clear days time was not granted to the appellant assessee to file their objections. Nevertheless, the assessee had filed assessee within the 2-day time limit granted had filed their objections. However, the authority had passed the order under section 148 capital A within bracket small d of the Act on 6/4/2022 without taking note of the fact that adequate time has not been granted to the assessee, and there is discrepancy in the dates on which hearing was fixed. Under normal circumstances, the court would have considered as to the correctness of the submissions made on behalf of the appellant to see as to whether there was any jurisdictional error in the decision-making process rather than the decision. However, what precludes us from doing so is the conduct of the appellant assessee. Admittedly, the order passed under section 148 capital A small within bracket small d was passed on 6/4/2022. Thereafter, the department had issued notice under section 143 within bracket 2 on 15/3/2023. The appellant had responded to the notice by the reply dated 16th March 2023, and thereafter in April 2023, the writ petition was filed. Thus, by the conduct of the assessee, it is seen that the assessee was not prejudiced on account of the alleged non-providing of 7 days time to respond to the show cause notice dated 21/3/2022. Therefore, we are not inclined to interdict the proceedings interdict the proceedings. However, we preserve the appellant's right to raise all contentions before the authority in response to the notice issued under section 143 within bracket 2 of the Act dated 15/3/2023. The appellant is granted 10 days time to file an additional reply to the said notice issued under section 143 within bracket 2 of the Act dated 15/3/2023, and the appellant is directed to enclose the bank statement, and on receipt of the reply, the adjudicating authority, the assessing authority shall verify all the details and take a decision in accordance with the law. With the above observation, the appeal stands disposed of. Next.
I'm good.
Serial number 11.
Oh, 115. Brother is also sitting back.
I'm for the respondent in this question.
Yes, Smita, what happened?
Lordship, I'm for the appellant. Your Lordship, this is an appeal against the order of the writ court. Lordship, this is an appeal against the order of the writ court. Your Lordship, the writ was filed for a simple prayer of quashing the 148A, for remanding the proceedings back to the assessing officer for disposing of our objections that were filed under section 148 in response to notice issued under section 148A(b). Your Lordship, if I may direct your Lordship your Lordship's attention to the notice issued under section 148A(b), which is on page 89 of this petition. Lordship, this notice was issued on 31st May 2022, and the
Bogus LTCG, 73 lakhs.
Yes, Your Lordship, and this is the only information that page 200 is the impugned order, my lord.
And page 96 is your reply.
Yes, Your Lordship. Before that, if Your Lordship may also see page 91.
91.
Where the limited information that was given to us was the value of the information value and the source of the PAN. That is it, Your Lordship. And against this notice, Your Lordship, we've also filed a reply, a very detailed reply dated 23 June 2022, which is on page 96, Your Lordship. Wherein, Your Lordship, we had raised 3 objections. The first objection is not valid because it's time bar issue on the issue of time bar. The second objection, Your Lordship, was on the point that the information that was received by us was very limited. We had only received one page, a single row of information, and the notice
That
was.
is page 98, para 8.
Yes, Your Lordship. That is our objection that the information
Incorrect
was.
assumption of facts, etc.
Yes, Your Lordship.
Then what did you?
Then also, Your Lordship, if Your Lordship may see page 100, which is also our reply.
Yes.
We have also stated out detailed facts of our case, wherein we have said that we have not transacted with Mr. Naresian. What happened in our case was there was a bulk deal of 5 lakh shares of the entity Messrs. Monotype India Limited. And this was done on a recognized stock exchange. And the shares were sold to my own relative, Mr. Pramod Rolia. So Mr. Naresh Jain is nowhere involved in this. Also, Your Lordship, on page 100 itself, in the last, we've given the table of all the long-term capital gains that were incurred to us in that year.
But essentially, it requires adjudication into the merits of the claim.
Yes, Your Lordship, and our only prayer here is that the case be remanded back to the assessing officer to consider our objection and dispose them.
You participate in the reopening proceedings?
We participated, Your Lordship.
No. You now 148 notice has been issued.
Assessment order has
also been passed
203, my lord. 203.
Without considering our objections, Your Lordship. If you see the
one considered, Your Lordship, from the order itself, it will
they
surface.
came to you very late.
Your Lordship, if Your Lordship may see the 148A order once on page 128.
That was under challenge before the writ court to Your Lordship, and the writ court to Your Lordship only comes to page 200 is the impugned order.
Your Lordship, once if page 128, Your Lordship, it is a 3-page order wherein they have not considered our objections, Your Lordship. All they have said
but
on
this Naresh Jain is part of that Swati Bajaj.
Your Lordship, we are not into the merits. We are only saying that if this can be remanded back for them to consider, because on page 130.
That is why, because the entries were found to be bogus, and there is a live link with the other, because there was an accommodation entry also. Only from the search and seizure it was found. It revealed that there is some excess.
The assessee company is Monotype India.
Yes, Your Lord. Your Lordship, also on page 130 of 148, Your Lordship. Your Lordship, the order has been passed without.
Come with a better case next time.
Your Lordship, if Your Lordship may consider just remanding this, we are ready to participate if their objections can be considered. Your Lordship, are only.
This intra-court appeal by the writ petitioner is directed against the order and so on. The appellant had challenged the reopening of the assessment by issuance of notice under assessment for the assessment year 2017, under the provisions of the Income Tax Act 1961. The learned single bench had taken into consideration the facts and circumstances, and in particular that an assessment order has already been passed under section 147 of the Act, declined to interfere with the declined to entertain the writ petition. The learned we have elaborately heard the learned advocate for the appellant, who would strenuously contend that the substantial objection which was raised by the assessee in the reply dated 2/3/2022 in response to the notice issued under section 148 capital A within bracket small b of the Act was not considered, and none of the facts were dealt with by the assessing officer while passing the order dated 23/7/2022.
Your Lordship, even the name of the assessee on the last page of the order is recorded incorrect. It's
under section 148 capital A within bracket small d of the Act. Therefore, it is submitted that the matter should be remanded back to the assessing officer to consider the reply given by the assessee in a proper perspective. As could be seen from the reply to the show cause notice, the assessee has not only mentioned about the absence of evidence being provided, the assessee has also furnished information to state that the proposal to reopen the assessment was on incorrect assumption of facts. This aspect has been dealt with by the assessing officer, and more particularly while passing the assessment order under section 147 of the Act dated 29/5/2023. Thus, the matter has travelled to the stage of an assessment order, and necessarily the SSC has to establish his case by producing by placing facts before the appellate authority. And at this juncture, the question of interfering with the order passed under section 148 capital A within bracket small d of the Act would not arise. For the above reason, the order passed in the writ petition is confirmed, the appeal is dismissed. However, we make it clear that the dismissal of the appeal and the writ petition will not preclude the appellant from raising all grounds in the statutory appeal to be filed against the assessment order dated 29/5/2023, in which the appellant would be entitled to contest that the reopening of the assessment itself is bad in law. All such contentions shall be decided by the appellate authority, uninfluenced by any observation made by the learned writ court or by this court in this judgment and order. Dismissed.
Serial number 40 wala.
My lord, may I request, my lord, item 30 to be upgraded in the next date of hearing?
Serial number 40 wala new contempt application. My lord, may I serve and came back because there is some urgency. My lord, your lordship dispose of the matter.
What to do, madam? We
My lord, this is first time contempt application. I serve and came back.
We will reach. We have come up to what all matters today disposed of. No, except one matter, every matter is disposed of. Let us see.
Well, item number 44, my lord. My lord, this is an application for modification of your lordship's order dated 11 July. My lord, there is a similar application, my lord, which is due to appear on Monday, my lord. A public interest litigation filed by another party in connection with the same property, my lord. So let it appear with, my lord, that matter, my lord.
affiliate side will
one indulgence.
continue in the second half.
Second half, original side, I have some matters, penny stock matter, but I have to leave the court,
great.
personal debate, my junior will be there, delay is there, sorry, order.
আমারও তাই নিউট্রন
Ordinance side daily list item number 1.
My lord, I'm for the appeal.
I'm
in
for
this
the
matter,
response.
Oh.
your lordship. There is a delay of 1309. But if
1309.
your lordship kindly takes up the section 5 application once,
No satisfactory
prima
explanation.
facie, if I can satisfy your lordship, I can be out from the courtroom, my lord, but I will not press on it. But the order was passed. If your lordship kindly comes to internal page 2, your lord. The order was passed on 7th of August 2019,
Yes.
and it was due to expire on 13th of December
December
2019, and it has been filed on 17/7/23, your lordship. Now, from clause A onwards of paragraph 3, your lordship, the dates have been mentioned. Now, your lordship kindly comes to page 3. Clause C doesn't speak of when was the assessing officer was asked to submit the appeal scrutiny report, but subsequently the appeal scrutiny report was submitted on 4th of December 2019. Chronologically, all the dates are okay, your lordship, but if your lordship kindly comes to page 4, that on 14th of February 2020, the Ministry of Law and Justice sent the information to the respondent regarding the engagement of the council. Then L, that is, thereafter the department was started to prepare all the annexures for filing the appeal before the Honorable High Court at Calcutta. And then the COVID starts, my lord. So there are two issues with regard to the change of the councils, and one is the COVID issue. That is why the delay has been caused.
But the limitation expired on
7
13/12/19.
13/12/9.
At that time, there was.
But that is why, your lordship, in the meantime, the steps which has been taken by the department, that has been narrated in the page 3, your lordship. Chronologically, all the dates have been mentioned.
If your lordship see page 7.
There is no
para
such
5,
delay in making the necessary, whatever the procedures they have adopted. There was no lacune on the part of the
7,
department.
para 5, 6.
And in the meantime, if your lordship kindly comes to page 5, clause P, that consequent upon the reconstitution merger of officers, even after the COVID period, during that interim period, your lordship, there was a change of officers also. And the strength was reduced to because it was not possible for them to run the show. So they, on the rotation wise, the officers were also engaged in doing their work. And the strength was also reduced. And page 6, your lordship, clause U, that is the period from 15/3/20 till 28 to this period needs to be excluded in the light of the judgment of the Supreme Court. Because that period of the limitation needs to be excluded.
Lordship, kindly see page 7, para 4 onwards. My lord, from 2022 to 23, pages are missing, then certified copy. There is no satisfactory explanation.
If your lordship so pleases, I can file a supplementary affidavit to that, explaining the reasons for the delay caused for that period, my lord, that page 7. But we have tried our best to satisfy your lordship, because there are the two issues, that is the COVID, the intervention of the COVID and the.
One issue is 14A that is covered.
Yes, that is covered, my lord.
But the other three issues,
That is also covered.
they have assessed the factual matters.
That is one with regard to the reduction of the gross profit, and the other one was for not giving a satisfactory explanation with regard to the whether they have maintained the purchase and the sale bills, and any payments were made to the creditors or not.
If you come to page 60.
Yes, my lord.
Page 60, paragraph 6.
Yes.
Line about 6 from the bottom. Or
We
10
note-
from,
we
however,
note-
the AO has disbelieved them on a specious plea that the road challan sales tax document were not produced, which the assessee has already explained. We note that AO has not made any inquiry whatsoever to find out the identity, creditworthiness, genuineness of Mrs. So-and-so, which had purchased the goods. We note that ML's documents were placed in pages 20 to paper book, reveal that it's a manufacturing company manufactures steel so-and-so. Is a regular income tax SSC PAN number assessed under 143(3) AACT, wherein the purchases made by the company, that is from the SSC, has been accepted by the department as genuine, and also corresponding sales made by it to other parties. Notice that the jurisdiction of so-and-so has been decentralized, came to the AO. Similarly, for the next purchases also,
These were not produced before the assessing officer. So the assessing officer did not get any opportunity to examine and verify those. Subsequently.
Tribunal says that the assessing officer did not conduct an inquiry. These documents were very much available and which was considered by the Commissioner of Appeals.
Yes.
How to re-adjudicate all these things? This appeal has been preferred by the revenue, challenging the order passed by the Income Tax Appellate Tribunal B Bench Kolkata in ITA number 491/KOL/2018 for the assessment year 2014-15. There is a delay of 1,309 days in filing the appeal. The impugned order was passed by the tribunal on 7/8/2019 and was received by the department on 18/8/2019. The appeal ought to have been filed not later than 13/12/2019, and if it had been done so, it would have been within the period of limitation. However, the appeal was filed before this court on 17/7/2023, and in that process, a delay of 1,309 days delay has occurred. The explanation sought to be given by the department is by placing reliance based by referring to the COVID-19 pandemic and the order passed by the Honorable Supreme Court. However, it is to be seen that the period of limitation for filing the appeal expired on 13/12/2019, much prior to the lockdown. Therefore, the subsequent, the question of relying upon the decision of the Honorable Supreme Court and trying to take advantage of the same would not arise. At the request of the learned advocates for the parties, the court has also examined the findings recorded by the learned tribunal on the merits of the matter, and we find that the learned tribunal has done a re-verification of the facts which was done by the Commission of Income Tax Appeal to examine the correctness of the decision taken. Thus, in this appeal, court is required to examine as to whether any substantial question of law arises for consideration, and there cannot be any review of the facts to take a decision. Thus, for the above reasons, this court is not inclined to condone the delay in filing the appeal. Accordingly, application is dismissed and the appeal stands rejected.
Item number 2.
Is all delay, no? When you stop. Item 2, 3, 4 dismissed.
My lord, my name should be recorded in.
You please give the slip.
Deeply obliged, your lordship.
Item number 5.
Item number 5, my lord, I am appearing for Union of India.
Item 5, who will appear? You are appearing in item 5.
Yes, sir. So my
My appeal, my lord.
How much time would you like to take? Because we have got a continuing matter specially fixed.
Lord, this appeal requires to be heard, Lord, because there are two applications, Lord. One is for stay, Lord, stay is virtually granted. Lord, another, Lord, is for bringing on record, Lord, documents which were not before the writ court, Lord, the single bench. Lord, that document, that application, Lord, subject to my learned friend, Lord, because those are all not admitted documents, Lord. Original application filed before the DRT.
If it is not opposed, we can order the application. But if it is opposed, then we'll hear the.
Yesterday.
That is
Order
GA
41, Rule 27 will not oppose, my lord. Let it be, my lord.
Yes,
My lord,
that's
stay
there.
to the execution is granted, my lord, because.
Please let us see the
Lord.
order sheet in GA1. All right. The GA1 on to the interim order granted on 19/12/2023 shall continue till the disposal of the appeal. Accordingly, GA1 2022 is allowed. In GA number 2 of 2023, the prayer sought for to bring the documents on record is not opposed and the application is allowed and the documents shall be brought on record. The appeal be listed for hearing. You give a date in October.
My lord, may I very humbly submit this?
Yes.
My lord, my client, my lord, is the original writ petitioner. My lord, he is facing extreme financial distress. He's a very small, my lord, businessman. My lord, and he is facing this distress because of, my lord, a fraud committed by the bank. And my lord, that is the reason, my lord, that is the impugned order.
मैटर हमारा है
Order, my lord, the honorable judge has held that there's a fraud which is committed by the bank and it is on record. My lord, today,
So we'll give a date in September.
I very humbly, my lord, pray, because, my lord, we are not getting that money from the bank. The bank, my lord, is supposed to give a money, my lord, a sum of money to us. And that is, my lord, stayed by, my lord, the appeal.
Anjani, give a date in September.
একটু আগে হবে
22nd we actually.
First week,
22nd ঠিক আছে।
first week এ যদি হয়।
First week এ রাখুন না। I'll have to.
আচ্ছা
না, আমার ফার্স্ট উইকে অসুবিধা হবে।
22nd.
Next.
Item number
my lord,
6.
if any prior date may be the 22nd of September, my lord. I'm only praying, my lord, if it can be, my lord.
29th of September. Instead of 29th.
My lord, instead of
No, that week it's not
very
possible.
well, very well.
29 night.
Deeply obliged, deeply obliged.
Great.
Item number 6.
May I please, lordships?
Yes.
My lord, this
Sorry, I'm sorry, my lords. I am appearing on VC lordship. Sorry.
this matter we have been, my lord, this matter we have
May I-
just, and this was supposed to be taken up on 16th. It's been recorded as to be taken as. My lord, Mr. Mazumdar is appearing in this matter. I was informed that his son is not well, is in the hospital.
Yes, your lord, if your lordship
So, my
would
lord,
be
take
kind.
it up on 21st August.
And where Mr. Goyal is appearing for?
Mr. Goyal is.
My lords, I'm appearing for my lords. I'm leading these arguments in this case, lordships, along with my friend, Mr. Mazumdar, my lords.
And your senior advocate is
Mr. Mazumdar.
Mr. Mazmundar is there is some inconvenience.
No, my lords, Mr. Mazumdar is assisting me in this junior Mazumdar advocate, sir. I'm to make the arguments in this case, my lords, your lordship.
But the respondent has not been served. Has been served
We
only
have
today.
just been served.
Just been served.
Now, my lord, this matter, they had kept it to be heard on 16th. It's come up today,
But
potently. It was
no,
supposed to
in
come.
the presentation form, the date is given as 11/8.
Okay, my lord. They informed that it was for 16th to us. My lord keeps it on
18th.
21st, my lord.
21st is Monday. Monday we'll have original say afternoon.
Yes, origin side.
All right. 21st, Mr. Goyal.
Your lordships, I'm your my lords.
Request of Ms. So and so. 21st.
I'm grateful.
Grateful,
my
your
lord.
lords.
Item number 7.
But I'm for the respondent.
The service. In the impugned writ petition, I challenge the order under section 148 AD and the notice under section 148 on 3 jurisdictional grounds. Your lordship are aware that after the amendment by the Finance Act 2021, if the search is initiated on or after 1st of April 21, the 153A, 153C provisions now no longer apply, but the new provisions apply. However, if the search is prior to 1st of April 2021, then the new provision of 148 doesn't apply, and old provision apply. In the present case, Your Lordship, the search took place in the month of January 2019. 28th of January 2019. In consequence of this search, search was not in my case, search was in case of some a locker operator. A locker was found in my name and some gold and silver ornaments were there, some statement was recorded. So that is the issue, Your Lordship. Now that they have issued the impugn notice under the amended provisions of section 148 post 1st April 2021. So my first plea, Your Lordship, is that proceedings are wholly without jurisdiction. In case of searches which has been carried on prior to 1st of April 2021, the provisions of 153A to 153C applies and not the amended 148. That was, Lordship, my first ground before the single judge. Second, Your Lordship, the sanction was unsigned. If the sanction under section 151 is unsigned, the proceedings are wholly without jurisdiction. Division bench of our court in 2 occasions has held that an unsigned notice or an unsigned sanction is wholly void of issue. Recently, Allahabad High Court in the context of 151 itself has taken this view that section 282A requires either a manual signature or a digital signature. But in this case, neither there is a manual signature nor a digital signature is there. The Lordship, the third ground before was that the sanction is mechanical. It relies on a wrong provision of law 149(1)(b), which applies where the reopening is to be done beyond a period of 3 years. In this case, the reopening was within a period of 3 years, and therefore the correct provision should have been 149(1)(a). Lordship, recently on Monday itself, 1st of August, Division Bench of Bombay High Court has taken a view that when a wrong provision is quoted, that means the sanctioning authority has not even read the sanction form. It's a mechanical sanction, and therefore sanction is bad in law. Lordship, these were my 3 original grounds before the single judge. And before Your Lordship, I am raising a 4th contention. It's purely jurisdictional issue, and Lordship, that can be raised at any time. That in view of new section 151A, the notice under section 148 need to be issued by the faceless assessing officer and not the jurisdictional assessing officer. In this case, your notice has been issued by the jurisdictional assessing officer. Recently, the single judge in our court itself has taken a view and granted stay on this particular ground, Your Lordship.
Now, these 3 grounds were urged in your reply to the 148AB notice.
Lordship, the first ground, first and the third was heard.
Raised.
Raised.
And how does he deal with that?
Lordship, only a cryptic observation that because there is a search and a statement is recorded, only 2 lines. If Your Lordship will see the disposal, page 40.
It starts at
Page 54.
Yes.
The relevant part, Your Lordship, is that
Page 54.
The reply was considered the day after, page 54.
Lordship, he reproduces my reply, and then Your Lordship, page 54, para B. In the first line, he writes about the 153C, then he narrates the entire fact, and the only disposal Your Lordship will find in page 55, para 9. Entire para 8, Your Lordship, is the reproduction of fact. Para 9 on page 55. Reply received from assessee against the show cause notice issued under section 148AB of the Act has been gone through carefully and taken into record as per section 148AC of the Income Tax Act. The view taken by the assessee is found to be incorrect and without any fact and hence not tenable. It is pertinent to mention that the assessee has admitted the unexplained investment in jewelry amounting to rupees so and so in his recorded statement on 5th of March 2019 before the DTIT in Kolkata. The contentions issue based, Lordship, that 153C provisions are applicable in case of searches prior to 1st of April 2001 and not these proceedings. There is not a single whisper about that. It has not been dealt with. And the other 2 grounds, Your Lordship, are purely jurisdictional issue. If Your Lordship will see page number 57. This is the form on which sanction is granted. Page 58 it ends. There is an annexure on page 59. There is neither a manual signature nor a digital signature. And if Your Lordship will see on page 57, column number 9.
Yes.
Time limit for current proceedings covered under, it says under section 149(1)(b) for more than 3 years but not more than 10 years. This, Lordship, is totally incorrect. This proceeding was initiated within 3 years. If it is initiated after 3 years, under the amended provision of section 151, there should be a sanction of principal chief commissioner. If your lordship will see on page 58, column number 22, there is a sanction of principal commissioner, which in my humble submission and admission that it is a correct authority, principal commissioner, because it is within 3 years. But if your lordship will see page number 9, point number 9, it says it is beyond period of 3 years. So sanction lordship has been totally granted mechanically.
And what happened? The writ petition affidavit was called for?
Lordship?
In the writ petition, affidavits were called for?
No, your lordship.
The affidavits are not called for, but your lordships regarding sanction, it is within 3 years, so but it has been done by PCID, but
No, what
Although
about the
my
other ground he has raised?
yes.
He has noted
Your,
it.
your lordship may admit the matter, let me not, because
You need to file a counter. But
Yes, yes.
why should he lose one opportunity? Let the notice proceedings remain stayed.
my
Let the writ petition be restored. You file your affidavit in the writ petition
lord,
and let the writ petition be heard out.
Your lordship, if your lordship please don't let it be, my lord, may I file our opposition here, my lord?
No.
My lord, I understand, I understand, I
Small
understand.
individual, I would also require your lordship's indulgence.
I understand.
If your lordship can deal with the same.
No, how do we test the correctness of this order?
Lordship. Let them
Or-
file a reply before your lordship.
No. Then we'll have to hear the writ petition.
I understand, yes.
Ah.
Yeah. Because, my lord, regarding, my lord,
small
he has
individual
raised 4
lordship.
points, my lord, in
How
the
many
reply, he has taken only 2 points, my lord, first and third, my lord, as my learned friend rightly said.
Jurisdictional points have been raised.
Yes. And regarding, my lord,
Lordship, issue of jurisdiction, it's a settled proposition,
But-
can be raised at any
Any
point of
time.
time.
it was dismissed at the threshold, my lord, so, my lord, affidavit has to be. And regarding, my lord, this,
This intra-court appeal by the writ petitioner is directed against the order dated 6 June 2023 in WPO 1072 of 2023. The appellant assessee had challenged the order dated 12th April 2023, passed under section 148 capital A within bracket small d of the Income Tax Act 1961 and the consequential notice issued under section 148 for the assessment year 2019-20. The learned single bench had dismissed the writ petition on the ground that the assessee will have ample opportunity in the reassessment proceedings, and accordingly the writ petition was dismissed. Agreed by such order, the appellant have preferred the present appeal. We have heard so and so. In the grounds which have been canvassed by the appellant in the writ proceedings are all touching upon the jurisdiction of the assessing officer to initiate the reassessment proceedings. The first contention which was raised before the learned writ court as well as before the assessing officer was that the reassessment proceedings is bad in law. On the ground that the alleged income based on the search action upon a third party is specifically conferred only in section 153 of the Act, and accordingly, recourse cannot be taken by assuming the jurisdiction under section 147 of the Act. Further, it is contended that the entire reassessment proceedings is void ab initio, as the provisions of section 153 capital A / 153 capital C overrides section 147/148 of the Act, and therefore it has to be mandatorily followed by the revenue. Further, it was contended that the amendment made by Finance Act 2021 expressly provides that the proceedings under section 153 capital C can be initiated only in such cases where search action was initiated on or after 1st April 2021, whereas in the case on hand, the entire search action as well as dissemination of information was made between January 2019 and June 2019, and accordingly the action of assessment can be only made, assessment if any can only be made under section 153 capital C of the Act. Apart from that, the assessee would contend that the jurisdictional assessing officer has no jurisdiction to initiate reassessment proceedings and it is only the faceless assessment center which would have jurisdiction. Since the appellant assessee has raised the jurisdictional issue, the same issue at the first instance before the assessing officer, the same ought to have been decided. Furthermore, the jurisdictional issue has been specifically pleaded and raised in the petition. Therefore, in order to decide the jurisdictional issue, it is necessary that the respondent department should file their affidavit in opposition so that a decision can be taken on the question of law which has been raised, questions of law raised by the petitioner. Therefore, we are of the view that the writ petition should be heard and decided on merits. And the opportunity is stated to be available to the assessee in the reassessment proceedings under section 148 of the Act would not be an adequate opportunity since the petitioner, as appellant assessee, questions the jurisdiction of the assessing officer to initiate reassessment proceedings, which issue would go to the root of the matter. Therefore, the writ petition has to be decided on merits. The learned advocate appearing for the appellant would submit that the appeal that the department that the matter can be decided by this court. However, this appeal being an intra-court appeal under clause 15 of the latest patent, the court would be required to decide the correctness of the order passed by the learned writ court, which had dismissed the writ petition on the ground, wherein the jurisdictional issue raised by the appellant has not been decided. Therefore, it is necessary that the writ petition should be decided by the learned single bench, wherein all the points can be urged by the appellant and suitably defended by the respondent department. For the above reasons, the appeal is allowed. The order passed in the writ petition is set aside and the writ petition is restored to the file of the learned single bench. The entire reassessment proceedings pursuant to the order passed under section 148 capital A within bracket small d of the Act dated 12/4/2023 and the notice issued under section 148 of the Act shall remain stayed till the writ petition is heard and disposed of. The appellant, the respondent department has directed to file their affidavit in opposition within a period of 6 weeks from a date and reply, if any, within 3 weeks thereafter. Let the writ petition be listed before the appropriate learned single bench during first week of December 2023.
Grateful, Lordship.
Next.
Your Lordship, just one indulgence. In the first paragraph, Your Lordship, you mentioned that proceeding under section 153C can be initiated in respect of search on or after 1st April. It should be before 1st April 21.
I've said
The
on
very first paragraph.
Sir, appeal. The first I said.
There is some typographical error here itself in one paragraph. My apologies, Your Lordship. In the appeal itself, there is some typographical error. The correct position of law, Your Lordship.
No, in ground number B.
Lordship.
No, where have you said that? In that? Oh, ground number E, para 4 of your memorandum. Ground number E. Stay petition or memorandum. Amendment made in the Finance Act expressly provides only in cases where search action was initiated on
Lordship,
or
my apologies, that is a typographical. My apologies, Your Lordship.
on or it should be.
It should be before 1st April 21.
Sir, I've said on or after 1st April. It should be before. I was thinking.
And Lordship, may I have a liberty to raise the issue of 151A, which is not there in my petition, in my rejoinder?
Definitely.
If Your Lordship,
You have raised it in the writ petition.
No, 151A, Lordship, has not been raised. That it should be by the faceless officer and not by the.
We have said that.
Lordship. Great.
Item number 8.
This is my appeal.
Your Lordship, I'm appearing for respondent number 4. A cross appeal has been filed as APO number 116 of 23. The matter will appear before your Lordship court on 17th of this month. Since both these appeals are connected with the same impugned order, it is necessary to hear both of them together for conclusive hearing. It's a humble prayer before your Lordship to
Both
fix.
need to be heard together.
Both need to be heard together.
I am for the council, my lord, respondent numbers 1, 2, and 3, my lord.
My lord, I have got two very short points, my lord, on which I can assail the impugned order. My lord, very settled principles of law. One, when a statute mandates something to be done in a particular fashion, it has to be done in that fashion, in no other
Rightly
fashion
so.
whatsoever. And my lord, my second principle is that if the edifice goes, the superstructure must fall. My lord, the statute is very clear how a conciliation proceedings have to be terminated. My lord, the termination has not followed that procedure. My lord, thereafter, my lord, arbitration.
Where is the order passed with the single bench?
My lord, it is in the memorandum of appeal. Your lordship is.
Please give the memorandum of appeal.
The impugned order proceeds on the basis, lack of bona fide on the part of the appellant and delay. Conciliation proceedings, my lord, were terminated in December 21. They come, my lord, in July 23. After participating, my lord, in the arbitration proceeding.
My lord will kindly see.
All right, let their objection also come up.
Yes, but my lord, these are my two main grounds. My lord, if the conciliation proceedings termination is wrongful, the consequential arbitration, the award thereafter, everything goes.
The learned advocate, you are appearing for the fourth.
Respondent number 4.
The learned advocate appearing for the fourth respondent submitted that as against the order passed by the learned single bench, a cross objection has also been filed in CO number.
APO number 116 of 23.
Oh, an appeal, not cross appeal. An appeal has also been filed by the fourth respondent in APO number so and so.
116.
They list this appeal along with so and so on 17th. On 17th.
Your Lordship, in the meantime, you will serve them the copy also.
On 17th, in the admission list, the learned advocate on either side are requested to exchange copies of the.
We have served, my lord. We are just awaiting their
appeal, the stay petition and the appeal memorandum. Next.
Public interest litigation, item number 9.
Ma'am, for the respondent Union of India.
Yes.
4 and 5. My lord,
State is in a
today is the fourth day.
Then
The date on
responsible
every
person
day,
is the
the
state.
date is the respondent who is the.
Your lordship directed the state to get the information.
But they are, I think, Mr. Sishwanna Bandyopadhyay is appearing. He is not inclined to appear in the matter. It's the fourth day. This matter is.
Why he is not? Then somebody else will appear.
But we don't know, my lord. But every day this matter is being adjourned. This is the fourth. Today is perhaps it's fourth or fifth day, my lord. My lord, it relates to the.
Anjan, can you ask somebody from the government leader's office to come? Some government advocate, somebody. Huh? You please wait for some time. Pass over.
Next matter, item number 10.
Okay.
Yes. $345. 345.
May it please the lordships.
You are referring to section 15 bar of jurisdiction. And you have said that LIC has to necessarily follow the procedure under the Public Premises Act.
My lord. And my lord, may I just recapitulate, my lord, in a nutshell? Not required. The point of submissions that both
As you have got your notes, you also.
both of your lordship, I have noticed, both of your lordships have taken note of this. Now, my lord, I was on the last occasion, my lord, when my lord, from the point, my lord, may I resume my argument while I was placing, my lord, the judgment of
Jivan Das.
Yes, that you already placed, 694.
694, but I have not discussed what are the observations. Kindly come to the Jivan Das. Well, it kindly comes to paragraph 1. This was a case, the appellant was
1949.
1949. And his contention was that on a monthly tenancy, and the LICI had sought to determine the tenancy under 106 of the Tenants Transfer of Property Act, and therefore the action was initiated under section 5(1) of 1971 Act. Now, there was a writ petition. The writ petition was dismissed. Subsequently, there was a I'm sorry. My Justice Bhattacharya. Now, this was the background, and kindly takes up paragraph 2. See, such and such for the appellant contains that the respondent corporation, being a public authority, before initiating the action under section 5, is enjoined to assign reasons which must be just and genuine for the purpose of its exercise, and its reasonableness must be tested on the touchstone of Article 14 of the Constitution. He further contends that unless the public authority justifies the action taken under section 5(1) of the Act before determining the tenancy under section 106 of the TP Act, it is violative under Article 14 of the Constitution of India. Now, pausing here for a moment, 5 is a contemplating action, followed by notice under section 4 and 7. This is the 5, how the estate officer is to adjudicate. Now, here the Hori Singh was quoted. I would be also placing the Hori Singh judgment. Now, the para 10 of Hori Singh says, the scheme of 1971 Act is that it confers power on the estate officer to issue notice to persons who are in unauthorized occupation to any public premises to show cause why an order of eviction should not be made. Unauthorized occupation, quote unquote, under the Act in relation to any public premises means the occupation by any person of the public premises without authority for such occupation, and includes the continuance in occupation by any person of the public premises after the authority, bracket, whether by way of grant or by any other mode of transfer, bracket close, under which he was allowed to occupy the premises has expired or has been determined by for any reason whatsoever. Then 3. Similar contention on the anvil of Article 14 was raised on the ground that when the Delhi Rent Control Act provides remedy for rejectment of specific ground and fixity of tenancy right, giving blanket power to the public authority under the Act is violative of Article 14. In Ashoka Marketing, this court by a constitutional bench in a slightly different connotation dealt with a similar contention in paragraph 68 and 69 of its judgment and held that the scope and provisions of the Public Premises Act cannot be cut down on the basis of the apprehension that the corporation like the Nationalized Bank or LIC, which are trading corporations and cannot be prescribed from buying the property in possession of the tenants at a low price and then evicting the tenants after determining the tenancy and selling the property at a much higher value because the value of the property in possession of the tenant is much less as compared to vacant property. The consequence of giving overriding effect to the provisions of the Public Premises Act is that the premises belonging to the companies and statutory bodies referred to in clause 2 and 3 of section 2E of the Public Premises Act would be exempted from the provisions of the Rent Control Act. This is also similar provision in this statement I would show. The action of these companies and the statutory bodies while dealing with the properties under the Public Premises Act will not have to be judged by the standard that they would not act as a private landlord, and their actions would be informed by reasons and guided by the public interest. Therefore, this court has negated the possibility of taking action against the tenants for letting out for higher rent or selling the property at a higher value. So this was the observations and finding of a constitutional bench reporting in Ashoka Marketing. Section 106 of the TP Act does indicate that the landlord is entitled to terminate the tenancy by giving 15 days notice if it is a premises occupied on monthly tenancy, and by giving 6 months notice if the premises are occupied for agricultural or manufacturing purposes, and on expiry thereof, proceedings could be initiated. Section 106 of the TP Act does not contemplate of giving any reasons for terminating the tenancy. Equally, The definition of public premises, quote unquote, unauthorized occupation under section 2G of the Act postulates that the tenancy, quote, has been determined for any reason whatsoever, unquote. When the statute has advisedly given wide powers to the public authority under the Act to determine the tenancy, it is not possible to cut down width of the powers by reading into in reasonable and justifiable grounds for initiating action for terminating the tenancy under section 106 of the TP Act. If it is so read, section 106 of the TP Act and section 2G of the Act would become ultra vires. The statute advisedly empowered the authority to act in the public interest and determine the tenancy or lease or license before taking any action under section 5 of the Act. If the contention of the applicant is given acceptance, he would be put a high pedestal than a statutory tenant under the Rent Act. Take, for example, that a premises is let out at a low rent years back, like the present one. The rent is unrealistic. With a view to revise adequate market rent, the tenant become liable to ejectment. The contention then is action is violative of Article 21, offending right to livelihood. This contention too is devoid of any substance. An owner is entitled to deal with his property to his own way, profitable in its use and occupation. A public authority is equally entitled to use the public property to the best advantage as a commercial venture. As an integral incidence of ejectment of a tenant/licensee is inevitable, so the doctrine of livelihood cannot indiscriminately be extended to the area of commercial operation. Therefore, we do not find any substance in the contention of the appellant and accordingly is dismissed. So, my lord, in nutshell, my lord, so far the reasons, it is not necessary for any reasons whatsoever. The Act itself provides and embodies with the provision, section 2G. I will take your lordship to the definition of unauthorized occupation. The submission of my learned senior friend is that there was no reason or the reasons are not proper. And even if it is for the estate officer to determine and to adjudicate. So far as whether I can give a go by to 91 agreement and proposes to increase a fair revision according to me, what would be according to the market value. This is also, I, even being a public authority, since I am an owner and landlord, I can ask for such increasement, and such increasement cannot be called for a violative of Article 12, 14. And if I do so, then it would be for a personal choice. And in that event, I would offend Article 14. Which I cannot do so being Article 14 of as a state or a state body. So far as third party is concerned, in this judgment, it provides that so far as taking action under the Public Premises Act, being a public premises, is wholly justified. In the event, the landlord or the owner finds that so far as letting out a property to a affluent tenant, and would not be proper or would be improper. And for that same, and that is the same finding, so far the guidelines is concerned, I will produce the Nusli Valley, the judgment report, the judgment reported in Nusli Valley Wadia, where even these guidelines, though this is not a statutory that they themselves have admitted. Now, what they are trying to say, is even though an administrative action is binding, I would show that even if an administrative action, even then it is not binding. Apropos to the same I would show that these guidelines have their later come up with a rider which says that these guidelines, whatever it in whichever forms, this will not apply to the affluent tenants and to the tenancy which are used for commercial purpose. And it is admitted that these are commercial purpose, and according to me, he is an affluent tenant. Now, whether he is an affluent tenant according to me and whether he is a bona fide tenant according to him, it is to be decided by the estate officer. So far is a fact-finding dispute, and constitutional court cannot go into a fact-finding dispute. Now, I'll come. Now, so far as on the earlier day, I was referring to Hori Singh. Let me place the Hori Singh judgment. This is the first constitutional bench which has considered the validity and intra vires of the Act. The reported in 1972, Volume 2, Supreme Court Cases, page 239, This was delivered by a honorable 7 judges bench. My lord, may I, my lord, take your lordships into trouble, my lord, from referring para 8. Why so para 8, my lord? Because the constitutional bench has also discussed the why some of the provisions of the earlier repealed act, my lord, was struck down by the Supreme Court, because there were two remedies. One are very lenient and one is very stringent. Now, kindly comes to para 8. The decision in the present appeal.
Yes.
The decision in the present appeal turns on the question as to whether the 1970 Act is a constitutionally valid piece of legislation. The 1971 Act is deemed to have come into force on September 16, 1958, except section 11, 19 and 20, which came into force on August 23, 1971. Section 11 of 1971 speaks of offense under the Act. The offense is that if any person, such and such, I skip over this portion, these are not very relevant to your lordship. Kindly comes to the next page. Section 20 also. My lord, where the recent important section 20, notwithstanding any judgment, decree or order of any court, anything done such and such, including such and such, notices issued, eviction such and such, my lord, such and such, any actions are taken, purported to have been taken or taken under the Public Premises Act 1958, hereinafter shall be deemed to be valid and effective as such thing or action which was done or taken corresponds to such. Now, my lord, kindly comes to para 9 onwards, which is very important for our purpose and also to consider, my lord, that why this section 15 has also given so much importance by the constitutional bench.
Yes.
Another important section of the 1971 Act is section 15. Broadly stated, section 15 speaks of bar of jurisdiction of court. Section 15 provides that no court shall have jurisdiction to entertain any suit or proceeding in respect of the eviction of any person who is in unauthorized occupation of any public premises or the recovery of any of the arrears rents payable under section 7(1) of the damage payable under section rent payable under 7(1) and damage payable under section 7(2) or the cost under section 9(5). The scheme of the 1971 Act is that it confers power on the estate officer to issue notice to persons who are in unauthorized occupation of any public premises to show cause why an order of eviction should not be made. Unauthorized occupation, quote unquote, under the Act in relation to any public premises means the occupation by any person of the public premises without the authority for such occupation and includes the continuance in occupation by any person of the public premises after the authority, whether by way of grant or by any other mode of transfer, under which he was allowed to occupy the premises are defined to mean any land, any building or any part of a building or and includes garden, grounds and out to such and such and such. Or pardon, public premises means any persons belonging to or taken on lease or requisition by or under the central government as enumerated in section 2E of the Act. The notice to show cause against the order of eviction shall specify the grounds on which the order of eviction is proposed to be made. Now here, my lord, pausing here for a moment, my lord, the ground of my lord, notice of eviction was, my lord, had stated that so far as the revision of rent that we had offered, which you did not agree. And that is the ground, my lord, and there are certain areas of rent. So, my lord, a notice under section 4 was issued for the eviction, 7(1) was issued for the arrears rent, and 7(3) was issued for the, my lord, damages and, my lord, so far the interests are concerned. And on that view, my lord, section 5 was the proceeding had initiated. The estate officer under the Act are appointed by the central government. The estate officer or the gazetted officer or the officers of equivalent rank. Corporate authority under the Act means any company or corporation or any committee or the authority as mentioned in the Act. The estate officer shall, for the purpose of holding any inquiry under this Act, have the same powers as are vested in a civil court under the Code of Civil Procedure when trying a suit in respect of the matters mentioned in section 8. These matters are summoning and enforcing the attendance of any person and examining him on oath. Secondly, requiring the discovery and production of documents. And thirdly, any other matter which may be prescribed. Section 10 of the Act provides for finality of orders in circumstances mentioned in section 10 of the Act therein. It is necessary to notice that this court on August 4, 1967 decided in northern India supra on the validity of the Public Premises Act 1959 and declared Section 5 of the Act to be violative of Article 14. In Northern India caterers, the state of Punjab leased the Mount View Hotel at Chandigarh for a period of 6 years from such and such. The estate officer gave a notice encouraging the appellant in that case to show cause as to why the order of eviction should not be made. Section 5 of the 1959 Punjab Act provided that if after considering the cause and the evidence produced by any person in unauthorized occupation of public premises and after giving him reasonable opportunity of being heard, the collector is satisfied that the public premises are in unauthorized occupation others. It was found that the Section 5 which the collector had to decide in which case he should follow one or the other provision. This court found that the government had two remedies open to it. One was under the ordinary law, the other was drastic and more prejudiced remedy under 1959 Act. Consequently, Section 5 was held to be violative under Article 40. That is what I said, my lord. So that is not a case of Section 15, what the Constitutional Bench, 7 Judges Court had held. The 1971 Act came into existence to validate anything done and any action taken and purported to have done or taken under 1950 Act. In the first place, the 1971 Act is made retrospective with effect from September 16, 1958, except such and such. In second phase, Section 20 of the Act, which is described as a section for validation for provides that anything done or any action taken or purported to have been taken or done or taken shall be deemed to be as valid and effective as if such thing or action was done or taken under the corresponding provision of the 1971 Act. In the third place, 1971 Act by Section 15 provided bar of jurisdiction of court in respect of eviction of any person who is in unauthorized occupation of public premise of any public premises. It therefore follows that under the provision of 1971 Act, which had retrospective operation from September 16, 1958, there is only one procedure available for eviction of person in unauthorized occupation of public premises. That procedure is to be found in the 1971 Act. The other courts have no jurisdiction in these matters. Kindly, my lord, if my lord so pleases, my lord, kindly underline these portions. The view of Article 14, which was found by this court in the decision of Northern India, no longer appears under 1971 Act. Then 13, the counsel for the appellants contended that orders made or eviction ordered under 1958 are not and cannot be validated by Section 20 of 1971 Act. The contention was amplified in this manner. Section 20 such and such, but this paragraph is not very important for your lordships. So kindly skip over this. Then kindly para 14. The validity of the 1971 Act depends on the legislature competence to validate anything done or any action taken or purported to have been done or taken under 1958 Act. The validation is achieved by enacting that anything done or any action taken or purported to have been done or taken shall be deemed to be as valid and effective as if such thing or action was done or taken under the corresponding provision of the 1971 Act. Now, my lord, here the Honorable Supreme Court, the 7 Judges Constitutional Bench also considered the validity of the Constitution, my lord, so far as whether the law is valid on the touchstone of my lord, Part 3 of the Constitution, whether it offends. And Lordship is well aware that the tests are my lord, basically on three counts. Whether the legislature my lord, presupposes competence over the subject matter. Secondly, whether by validation the legislature has removed the defect which the courts has found in the previous law. And thirdly, whether it is consistent with the provisions of Part 3 of the Constitution. Now, if these three tests are met, then of course, a law is said to be valid. And here, in Hori Singh, the first constitutional bench judgment has considered these all three tests are met, that the whether it's the legislation has a power, and so far as it has made all the requisite the parameters of part 3 of the constitution, and it also cures the loopholes or shortcomings which had in 1958 or 59 Act. Now, if may I continue thereafter? Anything done or any action taken under the 1915 Act is to be deemed valid and effective such and such. The court.
You read from the previous sentence.
I'm
the
sorry.
Result is that.
My lord, the result is that I'm extremely grateful. The result is that the 1971 Act is made retrospective with effect from September 16, 1958. Anything done or any action taken under the 1958 Act is to be deemed as valid or and effective under the provisions of 1971 Act. The consequence is that validity of action done or taken is to be tested with the reference of the provision of 1971 Act. This court in West Ramanand Electric, such and such, reported in case of AIA 1962, held that it is within the competence of the legislature to enact a law and make it retrospective in operation. In the West Raman such and such, the electric company vested in the state of Madras under an order dated such and such under the provision of section 4.1 of the Madras Electricity Act. The validity of the act was challenged. This court held that the act of 1949 was ultra vires. After the decision was pronounced, the Madras legislature passed the Madras Act 29 of 1954. The 1954 Act incorporated the main provisions of the earlier Act of 1949 and validated actions taken under the earlier Act. The West Ramanand such and such company challenged the 1954 Act. It was contended that the validation section was ineffectual and inoperative. The submission in West Ramanand was the notification in the year 1959 was invalid and the inoperative because in contravened Article 31. It was therefore contended that the notification was not supported by any authority of any pre-existing law. This court did not accept that contention. This court said that, quote, if the act is retrospective in operation and section 24 has been enacted for the purpose of retrospectively validating actions taken under the provisions of the earlier act, it must follow by the very retrospective operation of the relevant provisions that at the times when the impugn notification was issued, these provisions were in existence. That is the plain and obvious effect of the retrospective operation of the statute. Therefore, in considering whether Article 31, Sub-Article 1 has been complied with or not, we must assume that before the notification was issued, the relevant provisions of the Act were in existence, and so Article 31, Sub-Article 1 must be held to have been complied with that in the sense. In West Raman, this court referred to the provisions of Article 20 of the Constitution to emphasize the instance of the Constitution prevented retrospective operation of any law. Accent was placed on the words, quote, the law in force at the time, unquote, occurring in Article 20. The words, quote, the by authority of law, unquote, in Article 31, Sub-Article 1, were distinguished from the words occurring in Article 20. The court said that if subsequent law passed by the legislature were retrospective in operation, it would satisfy the requirement of Article 31, Sub-Article 1, and would validate the impugn notification in the West Raman. The ruling of this court in West Raman establishes competence of the legislature to make laws retrospective in operation for the purpose of validation or action done under the earlier act, which has been declared by a decision of the court to be invalid. It is to be appreciated that the validation is by virtue of the provisions of the subsequent piece of legislation. An illustration of an ineffective validation may be found in the case of a deputy commissioner such and such. In that case, there was Assam acquisition of land such and such of 1955. It was passed on April 11, 1955. The Assam acquisition of land of food control such and such 1960 was passed, validating the acquisition of land of which possession has been taken. The Assam government took possession of the lands in the year 1954. There was an order of acquisition under 1955 Act. The owner of the land was asked to submit claim for compensation under the 1955 Act as well as 1960 Act. Sharma challenged the validity under the validity of both the act. The High Court held so far as this matter is concerned, if may I say, this up to this paragraph 14, so the other parties concerned had dealt the other issues.
Retrospectivity, amendment, etc.
And competence of the state officer, and so far the public premises is concerned, and it has also ruled out that there is no other court which is enjoined any power so far as any action taken in courts of in respect of a public premises is concerned. It is not their case that this is not a public premises. It is not their case that I am not a landlord of them, because under section 19 of the Evidence Act they are also stopped, because the earlier occasion when there was a relationship, he has paid the rent. Now, my lord, one more thing, my lord, that if your lordship have the pleasure to consider, that even if, my lord, these guidelines are in force, it has, my lord, assuming we're admitting it has statutory, my lord, some essence. Even then, my lord, so far as the dictum of Hari Singh or the command, my lord, which has made, if I, my lord, take any other recourse not contemplated in the Public Premises Act, that would offend Article 14. Lordship may kindly also take a note of that. And whatever, my lord, the prejudice that being caused, if any, to the appellant, he can, my lord, has a remedy before the estate officer, and he can, my lord, place all the grievances for the adjudication. Because that is the only remedy which, my lord, has a non-obstante clause. And there is no, my lord, a contrary finding or, my lord, no other, my lord, view of the 7 judges constitutional bench reported in Hari Singh, which has given a comment that this is a non-obstante clause and there is no other forum, there is no other remedy. Now, my lord, lordship has, my learned senior friend has referred to Banatwala. I'm sorry, my lord, I was talking about Nuslewale Vadia, that was not Banatwala. I'm extremely sorry, my lord, I stand corrected for my shortcomings, my lord, saying, my lord, something Nuslewale Vadia also would be relevant, but so far as the riders that the Supreme Court has observed of 92 and 2002 guidelines, my lord, kindly takes Banatwala. Lordship has the judgment copy in my lord's brief.
Yes.
Kindly turns to, my lord, straightway first. Oh, a boiter to the other.
Yes.
Oh, no, my lord, a brief.
2011-13 SEC.
Yes. 2011-13 SEC 446. My lord, kindly straightway comes to. My lord, Justice Bhattacharya has. My lord, I have, my lord,
yes.
Kindly, my lord, straightway comes to paragraph 96. At page 489. My lord's copy are not telling. Oh.
Para 96.
Para 96.
Yes.
We may also note the subsequent clarificatory order dated 23/7/2003. Now, pausing here for a moment, Lordship may recall that on the other day, I have produced one of the 4 pages copy, the 2002 guidelines, which they have produced by a supplementary affidavit, but not being made a part of the appeal. And so far, the 92 guidelines, my lord has already seen, my lord, Mr. Mitra has shown. Now, kindly see the clarification. That was not produced before your lordship, but Banatwala has considered. 23/7/2003, the central government has made it clear that the guidelines dated 30th May 2002 will not apply to affluent tenants. Kindly underline, my lord. So, my lord, it itself, my lord, giving, my lord, all, give them a go by. And if your lordship, my lord, allowed them to be exhausted, to whatever extent without putting them any benchmark, even these guidelines itself will not help them. Now, may I read what are the clarificatory notes? The government resolution dated 38th May 2002 embodies the guidelines dated 14/1/1992 that your lordship has found in appeal brief for observation by the public sector undertaking. However, clarification was issued by OM number such and such dated 7/7/1993 that the guidelines are meant for genuine non-affluent tenants, and these are not applicable to the large business houses and commercial enterprises. So, the guideline itself being qualified. And it is abridged with such as reasons, that even if someone intends to follow, he cannot follow it if there is a commercial entrepreneur or there is an affluent tenant. If I find him a commercial tenant, if I find that he is exploiting my property being a public property, at the cost of public revenue, and also kindly appreciate, I will show from my LICI Act preamble that why I am being constituted to hold the public money, to give them a benefit by way of a return. And what is my source of income? By way of a letting out. This is a major source of income. And I am not using the money from my own. I am using and exploiting this property for the larger and interest of the public. And at 1200 square feet, if a lordship thinks of this proceeding has been pending for 2 decades. Giving them a cherished blessings to hold the property for more than 20 years by paying nothing or by paying with a meager money, which values nothing. And I could not exploit this property. I could not get a higher tenant because whenever the extra officer proceeds, he has come up by one applications. And my instruction is now this proceeding is pending only for argument. And he has come up with an application by of a writ petition and stalled the proceeding for last 4 years. Now, it is Banatwala. Lordship has seen para 96. Now see from para 93 onwards. At page 489. My learned senior adversary has shown to your lordship paragraph 92. The 92 has to be considered on the touchstone from para 93 onwards and not otherwise. Para 93. Yes, the para 92 my lord chief justice. Now, my lord, kindly see para 93 on the relevance of the guidelines. May I read, my lord?
Please, please.
My lord. In the instant case, the activities of the respondent LIC are controlled by the LIC Act. Section 21 of the LIC Act lays down the corporation shall be guided by the directions issued by the central government. The section reads as follows. Now, kindly see, section 21. This is a classified section which operates whether I would follow or not. The corporation to be guided by the direction of central government. In the discharge of its function under the Act, the corporation shall be guided by such direction in the matter of policy involving public interest, as the central government may give it to in writing, and if any question arises, whether a direction relates to a matter policy involving public interest, the decision of the central government thereon shall be final. So, in order to attract section 21 and let me binding, he has to show this was a direction of section 21, which is not. Because this is not a statutory force, my lord, it was not pronounced either under considering any constitutional mandate, or it follows the essence or touchstone of section 21.
Yes.
Now, the guidelines dated 30th May 2022 are not directions under section 21 of the LIC Act. We have referred to the general guideline dated 30th May 2022 laid down by the central government in this behalf. The guidelines 2I, 2.1 and 2.3 are relevant for our purpose. The guidelines 2I states that the provisions of the Public Premises 1971 Act should be used primarily to evict totally unauthorized occupants. Guideline 2.3 specifically states that it will be open to the public authority to secure periodic revision of rent in terms of the provisions of the Rent Control Act in each state. or to move under genuine grounds under the Rent Control Act for resuming possession. Thus, these guidelines specifically recognize the relevance of certain provisions of the Rent Control Act for their application to the properties covered under the Public Premises Act. It is stated in the guideline that the public authority would have rights similar to private landlord under the Rent Control Act in dealing with genuine legal tenant. It follows that the public authorities will have the obligations of the private landlord also. It is relevant to note that the purpose of this guideline is to prevent arbitrary use of powers under the PP Act. The relevance of the guideline will depend upon the nature of guidelines and the source of power. Kindly, my lord, if my lord so pleases with me, and my lords have the, my lord, if I've, my lord, so far as if your lordships and me are my lord, are ad item on, my lord, on the particular aspect, my lord, subject to corrections, your lordship may or may not, my lord, with me. But if your lordship are ad item with me, my lord, here, my lord, the basic question, my lord, that the relevance of the guidelines will depend upon the nature of the guideline and the source of power to issue such guidelines. The source of the right to apply for determination of the standard rent is Rent Control Act and not the guideline. And so far as my act is concerned, my lord, it is I have only one remedy under the Public Premises Act.
We'll continue on Monday.
Very good. As your lordship. My lord, Monday.
Monday, second half, after admissions only, after fresh cases.
Just Manarasi Bhattacharya is my lord, so far as 14th Monday is only a split up day, my lord.
So long you think.
Very well, my lord. If your lordships desire, my lord, I would come out Monday. I would come on Monday. Very well.
No, we'll list it on Monday. Any
I will come.
Any inconvenience, we'll
No, there would be no inconvenience. If lordship desire, my lord, I will put all my inconvenience aside and I will come and argue this matter.
I will also come.
My lord's desire at
or on Wednesday.
No. Keep it on Monday. Keep it on Monday.
Wednesday.
Monday.
No. If you have already committed, no.
Not committed, my lord. I was, but to be very honest, my lord, I was trying a scope, my lord, not to come on 14th.
All right. We have heard so and so.
Because there are other 15th is a holiday and Saturday, Sunday.
For continuation argument, list next Wednesday. That will be 16th August. 16th August. After admissions, after fresh cases.
Well, lordship can keep it on Monday. I would come.
Don't 2 decades it has happened. 2 days, nothing is there. You take your time.
Lordships are so kind enough.
You take your time.
Pass over matter item number 9.
16th is সকালে তো, মানে 16th on morning. Great.
Anybody from the state? Nobody is there. But we are waiting for him, madam, for 4 dates. 4 dates. Should we not, we will not hear the state government, we will straight away pass an order. Whatever injunction he asks for, we will grant. Somebody needs to represent. How long can we be waiting here? Please ask the state to come. Please ask the state to come. Where is Mr. Bandobadya?
My lord, he is in courtroom number 5, I think.
All right. This is a division bench. Courtroom number 5 is division bench or a single bench? Single bench.
Division bench.
Division bench. So which division bench you give preference?
My lord, we did not understand this.
No, doesn't matter. At least you should
My
give
lord,
preference.
he's coming, my lord.
Because 4 dates you didn't appear. What is the prayer in this matter?
Lord, in this matter, there is, as per direction of the Honorable Supreme Court, that under the Right to Information Act, first appellate authority must have the legal background. That was the point. In this matter, particularly Panchayat Pradhan, who is a non-matriculation, he cannot be the appellate authority. That is the subject matter of challenge of the first point. On the basis of that, the state take time for an instruction. My only short prayer was that the Panchayat Pradhan should be deleted and competent person should be appointed as a first appellate authority.
None represented the state government. Even today, when the matter was called, none appeared for the state government, and the matter was passed over. We are informed Mr. So-and-so, Mr. Bandyopadhyay appears for the state, but he is arguing another matter in another single bench. The state should respond to the prayer sought for in the writ petition on the next date by filing an appropriate report or at least a written instruction, failing which exemplary cost will be imposed on the respondent state. List on Wednesday.
List on
Wednesday.
Milord, in this matter, Milord, I am appearing for the state, Milord. Milord, the difficult,
You can wait, sir.
Milord, my apologies, Milord. We shall file the.
You file it, otherwise exemplary cost.
No.
If suppose you are inconvenienced, you have to make alternate arrangement.
Milord.
Office of the government pleader is not fixed by names or personalities. It is the office of the government pleader in general. So no case goes unrepresented on behalf of the government. We'll take this matter very seriously. Then we'll have to pass an order, place it to the Advocate General. It's a collective team.
Milord, there shall be an instruction, Milord, on Wednesday, Milord.
Mr.
without
Bandyopadhyay has been assigned a brief. If he is not available, you better make alternate arrangement. That's all.
Milord, on Wednesday, Milord, we shall.
That's how the office of the government pleader functions. There may be 1 lakh differences among you. We are not concerned about it. The office of the government pleader, the office of the public prosecutor, office of the solicitor general functions in such a manner. Otherwise, if you can't handle the brief, return the brief.
Milord, we shall.
9 years on that side, defending the government.
Milord, on Wednesday, Milord, we shall assist the court, Milord.
Before my Lord rises.
Yes, sir.
Can it be on Monday? If you, what was by consent you are saying?
All right, Monday. Whenever it.
That is not inconvenient for us.
I don't know. You don't know. Where we will go.
Milord, only one prayer, Milord. The report, can the report be report, Milord, or it has to be in affidavit, Milord?
Affidavit means your officer can come. He is such a big man.
No, Milord. Milord, affidavit means, Milord, we have to prepare the
Pradhan
affidavit.
of the Gram Panchayat can be an appellate authority. If he is a class 10 pass or class 10 fail, class 12 pass or class 12 fail, whether he can be, whether he should be a legal.
Milord, I am equipped with the instructions, Milord. I am ready to assist
Whatever
the
you-
court, Milord, at that point.
You assist.
Oblige.